guaranteed by sections 33 and 34 of the Constitution. Third, the need to interpret and apply section 53C Roman 5 of the Competition Act in a manner that better achieves the purposes of the Competition Act. Indeed, the CAC did not, in fact, refer to the purposes of the Act in its judgment. Fourth, it didn't give express consideration to the need not to supplant the discretion of the tribunal for its own, and also to the interests of consumers. Much of these considerations, we submit, received no mention at all in the CAC judgment. In contrast, the tribunal had expressed regard to the interests of low and middle income consumers, affordable access by them to product and product choice and price, and to the high levels of concentration in local markets. And the court will see these at paragraphs 45 and 53 of the tribunal's assessment. The result then of the CAC's decision is that Lewis is completely excluded from the major proceedings as a party, and a bad precedent, we submit, is set, which would in future make it almost impossible for any third party to meet the new threshold, which is high, to participate in major proceedings before the tribunal. Absent this court's intervention, we submit, the effect would be that large mergers are likely to proceed without proper scrutiny, and large corporate combinations would, for all intents and purposes, be immunized from third parties being able to participate in major proceedings. And we say this court's intervention is called for, and this court has jurisdiction on two grounds. The first is that the matter is of a constitutional character, and secondly, it raises important questions of law of public importance which are arguable. In respect of constitutional matters, first we say that the matter raises the Competition Appeal Court's obligation to promote the spirit, purport, and objects of the Bill of Rights when interpreting legislation, including Section 53(1)(c) of the Competition Act, read in the context of the Act as a whole, including its preamble and the purposes of the Act. And this is emphasized in the Mediclinic judgment at paragraph 36, along with many other judgments of this court, including Standard Bank and Coca-Cola and the rest. We submit that that obligation means that the CAC ought to have adopted an interpretation of Section 53(1)(c) Roman 5 that facilitated participation in major proceedings by Lewis, which promotes the spirit, purport, and objects of sections 33 and 34 of the Constitution, including the principles of natural justice, which are given effect to by Section 52(2)(a) of the Competition Act itself. And here we highlight that contrary to our learned friend's argument, we are not suggesting that Section 33 and 34 of the Constitution grant Lewis an automatic right to intervention. We accept that the tribunal enjoys the discretion, and the court will see that this is what the founding affidavit in the leave to appeal application mentions at paragraphs 91, 164, 165, at pages 001-46 and 001-87. Now, in this case, although purporting to apply the more permissive test, which has been affirmed by the Competition Appeal Court in various judgments, including Sunrise, the CAC adopted and applied a novel, restrictive, and unworkable test, which I have already referred to in discussing the overview. This restrictive and unworkable test, we submit, failed to promote the spirit, purport, and objects of the rights in sections 33 and 34 of the Constitution. It undermines those rights by excluding Lewis completely from the major proceedings, contrary to the exercise by the tribunal of his discretion. And we emphasize that the CAC did so without necessarily applying its mind to whether the old test was still correct or wrongly decided, and that departs from the principle of the doctrine of precedent, which is part of the rule of law, as this court has said in Kemps Bay Ratepayers Residents Association at paragraph 228. The second point we make on constitutional rights is the CAC effectively undermined on the constitutionality of the matter is the CAC effectively undermined and supplanted the tribunal's control of major proceedings, because if one looks at paragraph 47 of the CAC judgment, it started by asking the question that, or posing the problem that the CAC must be satisfied that the contribution which a respondent can bring to the proceedings meets the test laid out by the Competition Appeal Court. But that, with respect, is to start off by taking over the discretion itself, instead of asking whether the tribunal misdirected itself on findings of fact or was clearly wrong on findings of fact, and on the application of the test, whether it applied a wrong principle in exercising its discretion, which is not what the KEC started by doing, and showed no deference to the tribunal, contrary to the KEC's own judgment in Emeris, and as repeated and approved by this court in Mediclinic at paragraph 44. The third point we make is that the KEC concluded the tribunal failed to exercise its discretion judicially, and that implicates the tribunal's proper exercise of its powers, and that too is a constitutional issue. And the last of the constitutional points, we refer to what the major parties argue in defense of the KEC decision, and which is that the tribunal effectively outsourced or privatized its statutory powers. Now, that argument on its own raises a constitutional issue because it relates to the allocation of public powers, or implicates the allocation of public powers to the tribunal to adjudicate measures. So we submit that there is a constitutional issue. And there are arguable points of law. The first being the test or correct interpretive approach to section 1C of the Competition Act, and under what circumstances the KEC as an appellate court may interfere with and set aside the tribunal's exercise of discretion under that section by excluding completely a party that the tribunal had admitted on the basis that it requires its assistance. And this legal point is similar to the legal point that arose in Mediclinic at paragraph 37. Secondly, it's the question of the courts when the KEC can interfere with the tribunal's determination of the scope of intervention and the rights of participation that it grants under section 53. All of those two questions we submit are important questions of law which are arguable on the facts which this court will be called upon to determine. Then I leave to appeal must be granted, and I deal with first the prospects of success. My learned friend, Mr. Kotsudis, in dealing with the merits of the case, will address that. But we submit, firstly, that if the KEC had applied the proper and established test, it would have concluded that a tribunal exercises discretion properly. And to show that this is the case, in paragraph 61 of the KEC judgment, it concludes that it may be necessary for the tribunal to invite, either through the commission, to invite Lewis to make arguments or to participate in some lesser form, which is an acknowledgement that a proper case for participation has been made out. It is in the interest of justice to grant leave because the applicants, the issue raised is novel. This court has not had an occasion previously to determine the question around intervention or the KEC's interference with exercise of discretion by the tribunal on intervention. And the tribunal plays an important role in creating and maintaining markets in which consumers have access to and can freely select the quality and variety of goods and services they desire at competitive prices. And Section 53C is part of that tool in the exercise of the tribunal of those powers. And this court acknowledged this in Coca-Cola at paragraph 38. And we submit also that the restrictive and unworkable test that we submit the KEC adopted would undermine the tribunal's ability in the future to admit parties where it assesses that they may assist it in the adjudication of measures to discharge its functions. And so we submit on that basis that it's also in the interest of justice to grant leave to appeal. And given all of those considerations, we submit that the court has jurisdiction and leave to appeal should be granted. And I leave the opportunity to my learned friend, Mr. Kotsudis, to deal with the merits of the appeal. Thank you, DCJ and justices.
Deputy Chief Justice and Justices, in dealing with the merits of the appeal, I'm going to address 4 topics as the time allows. Firstly, why the tribunal admitted Lewis. The tribunal explained in detail how Lewis was able to assist it. Secondly, I'm going to address why the CAC set aside the tribunal's admission of Lewis. It reformulated the test for intervention. Thirdly, I'm going to address why the Competition Appeal Court's exclusion of Lewis and its reformulation of the test leads to a limitation of the rights for a fair hearing and procedural fairness and undermines the truth-seeking function of the tribunal in relation to a large merger. And finally, I'm going to address why the tribunal's exercise of its discretion in granting admission and procedural rights to Lewis was appropriate and justified by it, and why there was no basis for the CAC to interfere with the exercise of this true discretion. So beginning with the first topic, in various points in the tribunal's judgment, it explains why Lewis can assist. For instance, reading from paragraph 55, it says Lewis was able to demonstrate detailed knowledge of the various players in the market, their offering, and the market realities of whether they are likely effective rivals of the merging parties. Similarly, it said in paragraph 66 that Lewis demonstrated its ability to provide significant and material evidence on the nature of competition in the market, the closeness of competition, and the characterization of regional and local markets. And finally, in paragraph 62, it said that it is material to its determination. It's material whether Lewis's submissions or the merging parties and the commissions on the nature of the markets are correct, i.e. it's material who's right about the nature of this market. Now, you'll see all of that in paragraphs 55, 56, 62, and 65 to 69. It's important to understand that these issues are precisely the issues that have to be determined in a merger inquiry of this nature, which is a merger in relation to a differentiated product market, which is the retail of furniture, and where the considerations of whether the merger will lead to anti-competitive effects and a substantial lessening of competition require, and I quote from the Commission, a determination of a thorough assessment of the closeness of competition between purported alternatives and rivals. So that's the crucial inquiry. What is the closeness of competition between the purported alternative product offerings and the rivals in the market? And this is stated by the tribunal at paragraph 48 of its reasons. And that is, we say, standard economic theory, and has been well stated by the tribunal in multiple judgments, including Axel Nobel and the We Buy Cars mergers, and we give the reference for those at paragraph 20.2 at footnote 37 of our heads of argument. Now, the tribunal therefore set out in detail how Lewis was able to assist the tribunal precisely in the necessary competition assessment that it had to determine in order to assess whether or not this merger would substantially prevent or lessen competition in the market. And this aligns precisely with the standard test for intervention in the tribunal as created by the Competition Appeal Court in Anglo and crystallized in community healthcare. And that test is there a material interest which aligns with the Act's purposes, or is there an ability to assist the tribunal in the carrying out of its statutory mandate? That's what the community healthcare sets out the test, and we quote that in paragraph 35 of our heads. Now, interestingly, the merging parties accept that that is the test, that the test is, do you have a material interest, or can you assist the tribunal? That's the test. They accept that at paragraph 58 of their heads. They say, yes, the community healthcare test is the test, they say, paragraph 58 of their submissions. But importantly, when we turn to the Competition Appeal Court's decision, that isn't the test that the Competition Appeal Court actually applies in order to exclude Lewis. Because, as my learned friend Mr. Manetti has already said to you, what the Commission in fact says in its judgment is that what Lewis had to demonstrate and what the tribunal should have applied is the question, is the information and evidence presented by Lewis such that it could not have been, and not would not, had not, but could not have been obtained elsewhere, even after requiring further investigations by the Commission? And that's clearly stated in the summary of the tribunal's reasons in paragraph 52, as well as in paragraph 48. And it's particularly the Competition Appeal Court says that's the fundamental test. But as I've shown you, that isn't the fundamental test. That's not what community healthcare says. This is a new and novel test. And it has a stifling of the tribunal's truth-seeking function. And that can be demonstrated in this very matter. Because here, a knowledgeable insider who has demonstrated its ability to assist on the very questions that the tribunal has to determine in order to consider whether there has been a substantial lessening of competition, has been excluded. So in summary on that point, what we see is that the Competition Appeal Court doesn't say the tribunal erred in finding that Lewis could assist. It doesn't go through each one of those various paragraphs where the tribunal explains how Lewis could assist. It doesn't say that it erred. It doesn't even say that it misused its discretion in coming to those factual findings. Rather, what it says is that the tribunal applied the wrong test. It should have asked, is the evidence and information that Lewis presents such that could not be obtained elsewise from someone else, including the commission? And this is particularly startling in this particular case because Lewis has already demonstrated its ability to assist in quite a unique way. It presented insider information of the nature of competition and showed why the Competition Commission's assessment of the merger in its merger report did not properly understand the market and the competitive set. And in fact, in this particular merger, that led to a dramatic before and after situation. Before Lewis sought to intervene, it is accepted, and the tribunal says as much, that this was headed to an in-chambers determination of the merger by the tribunal without a full hearing. After it sought to intervene, the tribunal realized, because of the issues pointed out by Lewis, that the Competition Commission had not done a proper job. It had failed to properly analyze the closeness of competition in this market, the primary question. Even the Competition Appeal Court, in dismissing Lewis's judgment, notes the same thing. It says that the tribunal was correct to find that the commission had not done a proper job and should be asked to make further investigations. But the only reason that those issues were identified is because Lewis intervened. In a world where Lewis had not sought to intervene, there would have been no revealing of those issues. The tribunal wouldn't have known what it did not know. Because, of course, it should be remembered that before Lewis's intervention and even after it intervened, the merging party's position was that the competition report and the assessment by the commission was adequate. They say, and I quote from paragraph 122 of their answering affidavit in the leave to appeal, 011.120, that the report was adequate for a merger of this nature, which raises no competition concerns. And yet, after and because of the intervention and the tribunal's reconsideration of the issues, given the points made by Lewis, it's now accepted that there are issues that need to be further investigated by the commission. Thus, Lewis has demonstrated a credible merger-specific concern that a merger in its market is likely to lead to a substantial lessening of competition, and there will be an irreversible restructuring in the market in which it competes. Thus, it's clearly indicated that it has a material interest in the merger inquiry before the tribunal. And therefore, to exclude it is clearly unfair and deprives the tribunal of important views. Now, what do the merger parties say in answer to this? Well, they say, interestingly enough, as far as we can understand from their written submissions, that in fact Lewis will have Audi. And they say it will have Audi, or that there's no procedural unfairness for two reasons, as we understand it. In paragraph 30 of their heads, they say Lewis will have Audi, as we understand it. They don't use the word Audi, but they say Lewis's views will be placed before the tribunal. They say Lewis's views will be placed before the tribunal by the commission, they say, and that's sufficient. And we say that this is logically absurd, but also makes a mockery of the requirements of Audi Altrum Partem. Because what the commission would be the one putting the views before the tribunal, but it has disagreed with Lewis's views. So, in fact, what the merging parties would have this court accept is that Audi is achieved in this matter because the investigator who rejects the position of Lewis will summarize that position, tell the statutory decision maker, the tribunal, why it's wrong, and that's sufficient, without any ability by Lewis to demonstrate that its views are correct and the commission's are wrong. Secondly, the merging parties seem to say at paragraphs 83 and 84 of their heads that Lewis's submissions are duplicative. So therefore, there's no need for it to be involved in the merger inquiry. But once again, this is not borne out by the papers or the findings by that tribunal, because the fundamental issue in the tribunal, even recognized by in the Competition Appeal Court, was that there were fundamental different views on all the key merger inquiry issues between Lewis on the one hand and the merging parties and the commission on the other. In fact, as the tribunal says at paragraph 49 of its judgment or reasons, there are material differences between the versions of the parties in this matter regarding the substantive issues on which our assessment of the likely unilateral effects of the merger will turn, including the nature of competition, the competitor set, and the prospects of future competition. So on all the key issues, there are significant disputes. So there cannot be duplication where Lewis presents a view in contrast over against the view advanced by the merging parties and the commission. In summary, the tribunal clearly applied the pre-existing test. Can Lewis assist? In fact, Lewis demonstrated its ability to assist in multiple ways, as I've already discussed. The Competition Appeal Court changed the test and excluded Lewis in a way that clearly violates the requirements of a fair process and a fair hearing under Section 33 and 34, and indeed the requirements that the tribunal hearings are in accordance with natural justice, as required by Section 52 and 2A of the Competition Act. And this has two fundamental difficulties. Firstly, it robs Lewis of an opportunity to advance its cause of action and its theory of harm in this market before a final determination that will irrevocably change the market. But more importantly, it also robs the tribunal of full submissions and full argument on the very issues it has to determine. And we well know, and we've given the references in paragraph 54, footnote 86 of our heads, we well know that procedural fairness has value not just to the party who exercises the right, but to the decision maker. It has an instrumental value, and it leads to better quality decisions. And we say that is harmed here, where the decision maker says, I want this party to make submissions before me, and it's robbed of that opportunity. Now, turning to the last thing I would make one last point in this before I move on to some of the procedural rights. This court in De Beers NO at paragraph 11, and we give the reference in paragraph 52 of our heads, footnote 85, it says this, it says, since procedures that would render the hearing unfair are inconsistent with the Constitution, courts must interpret legislation and the rules of court where it is reasonably possible to do so in a way that would render the procedures fair. And we say that the Competition Appeal Court's approach here renders the merger hearing unfair in a harm both to the intervener and to itself and to the decision maker, the tribunal. Now, moving across in my last few minutes to the procedural rights. And we say, well, there are obviously two parts to the decision. Firstly, there's the decision to allow a party to intervene as a participant, and then there's the decision as to what rights of participation to grant them. And we would say that the tribunal correctly provided Lewis with procedural rights to make its intervention meaningful, because obviously, once you've been allowed an intervener in, you have to allow its intervention to be meaningful. And it's quite clear that the Competition Appeal Court has said, and we give references in our heads of argument to these, but that intervention must be meaningful. And the Competition Appeal Court has said this in Northern in paragraph 19, and in Sunrise in paragraph 19, it makes clear that there must be a meaningful right of participation. And in this particular case, the tribunal in paragraph 69 to 79 very clearly sets out why the rights it's given Lewis are necessary. Now, we would say secondly on that when the tribunal decides what rights to give an intervener, it exercises a true discretion. And therefore, as this court has made clear in Mediclinic at paragraphs 82 and 83, it's not for the Competition Appeal Court to to disturb that true discretion unless it can show not just that there's an error or that it would have done it differently, but that there's a material misdirection. And we would say
Mr.
that in this,
Koutsoudis,
yes.
Mr. Koutsoudis, you've run out of time. I'll give you 2 more minutes to finish this point.
Yes, thank you, Chief Justice. So we would, using the 2 minutes wisely, we would say that in this case, the Competition Appeal Court would have to have gone right by right and explained why there was a material misdirection on each one of the rights, and it didn't do that. It didn't explain why each of the reasons given by the tribunal for the rights given were wrong. Secondly, we would say that when you look at the order, there's been much debate about how if one looks at the order, but this court has said in numerous instances, and we give the references at paragraph 69 of our heads, that you interpret an order in light of the reasons given for that order, because those show the purpose and intention. And we would say here, when you read the order together with the reasons, it's quite clear what's intended by the Competition Tribunal in this matter. But even if there's any doubt about that, we say in this particular order, there was a very interesting provision added, paragraph 7.1 and 7.2, where the tribunal said, we will keep control. We have the right to limit your exercise of rights, and we require that all your exercise of rights are subject to our timetable, so that there could be no danger of Lewis misusing any of its rights or going beyond the strictures of what the tribunal intended, because it kept control. So Lewis's argument is not a trust us argument. It's a trust the tribunal argument. It is the decision maker. It will police this, and it's specifically and expressly kept control under paragraph 7, which it explains in 81. It says we've kept control to make sure that this process goes smoothly and we can control any intervention by Lewis. So in conclusion, then, Chief Justice and Deputy Chief Justice and Justices, Lewis has made out a proper case for intervention. As the tribunal found, it could assist in relation to whether the merger in its market would substantially lessen competition or not, the primary inquiry. The CAC overturned that based on a new test that is not only unfair and not in accordance with natural justice, but improperly interferes with the tribunal's exercise of its discretion in determining that Lewis could assist and providing with rights of assistance. And it's therefore appropriate to overturn the Competition Appeal Court's decision and to allow the tribunal to manage Lewis's intervention and determine the merger in accordance with its order and reasons, in order to ensure that a merger of this nature, which would lead to an irrevocable change in the market, is properly scrutinized before being approved. And on this final note, I would make this point. This court has recognized in Mediclinic, quoting from the judgment in the Competition Appeal Court in Imaris, that it's of absolute importance that in a merger, before you approve it, you determine, will there be a substantive lessening of competition? Because once you've made that decision, it's irrevocable. The harm, if there is harm, will have occurred and you can't undo it. And therefore, scrutiny is essential. And so where the tribunal has told us that it requires the assistance on the very issue of whether there will be a substantive lessening of competition, it would be very odd to then remove its ability to hear that evidence and to hear those submissions from an intervener. Thank you, Deputy Chief Justice and Justices.
Thank you very much, Mr. Koutsoudis. I think colleagues will put questions to you now. Colleagues? Are there any questions for...
DCJ, may I go first?
Please go, Justice Majid.
Thank you. My question is, it's always difficult when two counsel argue different aspects of the case. So while Mr. Koutsoudis is here, I'm going to ask him on the merits, work it backwards then and ask Mr. Maneche just one aspect on jurisdiction, which in particular constitutional jurisdiction. But let me ask the one question on the merits, Mr. Koutsoudis, and it starts at the end with remedy.
Yes.
Now, the order of the tribunal, which the respondents, the merging parties, fiercely criticize as being too wide, and particularly the access that is granted to what they say is confidential commercial aspects, and those will only be granted to the legal representatives and your economic advisors, and I say you, I mean Lewis stores. That's the first aspect. What do you say about that, Mr. Koutsoudis, that this order is too wide? I may interpose this by saying that I've seen similar orders and at least one case of the CAC that has been referred to in these proceedings in Northam.
Yes. Justice Majid, can I answer that in at least two ways? Firstly, each merger must be determined, and the access to rights must be determined on the case before the tribunal. So that would be the first. And what I would say is that it's not as if the tribunal didn't explain why it gave the rights it gave. It explained that from paragraph 69 onwards, each one of the rights, it explains what those rights. Sorry, paragraph 69 onwards. So if
69, yes.
Yeah, from 69 onwards, it explains all of the rights it gives Lewis. So it begins with sorry, not my mistake. Sorry, Justice. It starts with 69, and then it goes on and explains each of the rights it gives and why that access is necessary. So that would be my first submission. And my point, and the point is this: the Competition Appeal Court doesn't come back and say, well, this right is too broad in this way, and I don't like your reason. It doesn't do that. And it would have had to. It can't simply say, oh, but this is a broad right. These are broad. Secondly, I would say, yes, you're right, Justice Majid. The Competition Commission in tribunal in different matters does give these type of rights to participants. And there are different orders that one can refer to where such rights have been given. The third question you asked me is particularly about access to the record. And we would say that should be the least controversial. All that is being granted, so just I want to make a few points just practically on this. Firstly, one has to understand something. The document they're talking about is the merger record. Those are all the documents that were before the commission. That merger record has been filed with the tribunal. And in fact, if you look at the tribunal's reasons, it references that merger record. So that record is before the tribunal. We would say it would be a very odd situation in a hearing where participants own legal counsel under a confidentiality seal and it's economists. They can't even tell their client. At least they can't see the documents that are before the tribunal, because that would mean that a decision maker is sitting with documents in a star chamber where only it and one side of the argument has seen those documents. And we say that raises such significant procedural fairness issues that it would have to be justified. And so it's actually the justification has to go the other way. If you want to say that just lawyers and economists under seal of confidentiality, they can't show their client, can't see documents that are before the decision maker, we would say you bear the onus of justification, because that is a star chamber type of scenario.
And then you will know that the respondents then criticize the tribunal for saying that it will only grant access to Lewis to the merger record, so that there is nothing that will trigger buyer power concerns. But it says then the tribunal goes on to grant intervention to your client, to Lewis Stores, regarding the entire competitive effects assessment under Rule 12A2, which includes countervailing power. That's another criticism of the order, in the sense that it's too wide. Any submissions on that?
Yes. Justice Majid, once again, can I take that in a few parts? So firstly, I want to go back to my first submission. You read the order about the competition intervention granted to Lewis together with the reasons. And the reasons make clear that the tribunal believes that Lewis had not done enough to advance a buying power theory of harm, and that its primary theory of harm was unilateral effects, basically a merger leading to the possibility of rising of prices for consumers. And so therefore it doesn't give it that right. The mere fact that the long list of factors in 12.2a2 may reference countervailing power doesn't mean that we're in on buying power, because countervailing power is a broad term. And in fact, one of the usual meanings for that would mean that is there a countervailing power on the part of consumers to basically stop any ability to rise prices, because they have the countervailing power to choose different options. So you can't read countervailing power as meaning buying power. They're not the same terms. But we would say if there's any doubt about that, you read it with the reasons. And not only do you read it with the reasons, but the tribunal itself is being given itself the power to limit Lewis. So if for some reason there's some concern that Lewis will try and do more than it's got, take further steps than it is entitled to, the tribunal who made this order and gave its reasons will rein it in. So I think the risk is more imagined than real.
And lastly, they criticize the fact that the tribunal then grants access to parts of the record of the major record that deals exclusively with public interest issues. Do you have the same response to that?
Yes, so I think once my primary response is the one I gave you at first, and I think it's a species of that, which is to say, just to be clear, it's given access to the full record because that's been filed, and those are the documents before the tribunal. It's only given it to Lewis's attorneys and economists. They can't use it and show their client. They can just see what's before. If there's nothing relevant in the section in documents that are purportedly in relation to public interest, if there's nothing in there that has anything to do with competition, well, they can't do anything because remember, all of their rights to make legal submissions, to make argument, to cross-examine, are all limited by the scope. And it's very clear. The scope in paragraph 4 of the order is very clear. We are out on public interest. There can be no doubt. The scope, we are not in on public interest. All that is referenced is the competition, substantive lessening of competition. There's no reference to the inquiry under public interest. We're out. So it's simply saying, make sure that you have a full access to the record your lawyers can see, because there may well be documents that someone says, for instance, the commission, are public interest. But even Lewis's lawyers would not be able to test whether that's true without seeing those documents.
In sum, then, are you saying that this tribunal order is not too wide? It's properly underscored by its reasoning, and that is not. There's no warrant for this court to trim it down. Is that the summary of your?
That is my submission. Yes, that is my submission.
Now, just remind me. In the written submissions I read, and I can refer you in particular to paragraph 37 of your written submissions at page 14. You make the point that community healthcare and Northam and Anglo Capital cases have all set the test for intervention at a certain level, and you then say this is a novel test that's introduced. And then you talk about one previous CAC decision in which the judgment seems to have gone upstream compared to those cases. Which case is that? You seem to suggest that there's a case where it seemed to have changed the direction of the Northam and Anglo Capital cases.
Yes, as I recall it, it's in African data centers, but it's not. In that case, all that was said is there's a reference to unique insights. That's all there's some reference to unique insights, but it doesn't.
Yeah.
It doesn't add the very strong form view that the CAC has now said, which is that it's information that no one else could, including the commission. So that's completely new. There's just a reference to unique. It doesn't explain what it means by unique. So it doesn't know if it's unique at the time you intervene or what the Competition Appeal Court has said, which is basically perpetually unique in the sense that no one else could possibly do this, even after you've told them what to do.
It's almost a prophetic sort of call that nobody in future will do. Well, as I read African data centers case, it does refer to Northam and to community healthcare, which has gone before approvingly. So
Yes.
Well, that was it from me. Sorry.
Yeah. Sorry, Justice Majid, I'm just agreeing with you. Our submission in our heads of argument was exactly that, which is to say, even though there's a throwaway line about unique, African data center specifically restates the community healthcare test. So it doesn't purport to change the test.
No, thank you. DCJ, thank you, Mr. Koutsoudis. That's all I had for Mr. Koutsoudis. I don't know if you want other colleagues to deal with Mr. Koutsoudis before I move to constitutional jurisdiction with Mr. Manecha, or should I just finish my questioning and ask Mr. Manecha to respond?
I think it's better if you do it that way, Justice Majid, please.
Thank you. Thank you, Mr. Koutsoudis. Can I ask Mr. Manecha, on what grounds of constitutional jurisdiction you rely? Do you still rely on the right to access to court, the Section 34 right, or not? Because I have a problem with that one, and I'd like to put my problem to you. If Mr. Manecha could perhaps deal with that.
Um, Mr. Maneshi, you're on silent.
I was mute. Sorry, Justice Majid. I was submitting that we rely on it to the extent that what Section 39(2) requires is to promote the spirit, purport, and objects of the Bill of Rights of Section 34, and that in line with Section 52, referring to principles of natural justice, that the interpretation must promote that spirit. We're not suggesting that major proceedings must be equated to inquiries into contraventions of the Competition Act, which the CAC also has described as different from major proceedings. Simply,
Well, can I ask you this? I'm sorry to interrupt. I mean, you've had a full hearing in the tribunal and the CAC. Surely there can't be a complaint that you haven't had right to access to court. I've never heard an argument before, and please tell me if I'm misunderstanding you, that because a court hasn't applied Rule 39 of the Constitution in an interpretive exercise, that therefore you have now been denied the right to access to court. Or am I misunderstanding the argument?
no, I accept that. What we are merely submitting is in interpreting the section, one must give effect to those values, not that there is a breach, as in what would arise under Section 38 of the Constitution. But what we submit in respect of the value underlying Section 34 is the ability of Lewis to advance the theory of harm before the tribunal, that its complete exclusion denies that, doesn't promote that as a value, and because of the test is applied.
Let me conclude my questions to you by saying this, and don't put too much store on it, don't read too much in it. It seems to me that if you come home on general jurisdiction, you don't really need this convoluted Section 34 Constitution jurisdiction. As I said, don't read too much in it. I'm just saying, I'm postulating hypothesis.
Justice Majid is correct. The court, we can come home on either of those. We don't have to come home on.
No, thank you. Thank you, Mr. Maneshi. Thank you, DCJ.
Thank you very much. Thanks, Justice Majid.
DCJ, I have a question for Mr. Kutsotias. The Section 34 question has been raised. The major parties say that Lewis is aggrieved by the CAC's application of the settled test to the intervention application. What do you say to that? And when you respond to that, you can also look at para 49 of the CAC judgment, where the CAC said that the approach of the tribunal, they applied incorrect test for intervention on the basis of the case made out by the respondent in its affidavit in the intervention application. The test concerned the unique contribution which the respondent could make in producing the relevant evidence before the inquiry that it regrettably failed to do. Is that the proper test, or is it the one that you say is now the new test that has been formulated by the CAC, or what?
Well, thank you, Justice McClunkler. So I think that there's a few answers to that. So firstly, if you read, one doesn't read, we would say 49 in isolation, but it's clearly the case that the test is the ability to assist. That's what community healthcare says. And so to add additions to that and say it must be a certain kind of assistance, we say changes the test. That's A. Secondly, we say that the Competition Appeal Court doesn't stop at paragraph 49, because if you read on, you'll see that it says the same thing in different ways and explains what it means by unique contribution. Because when you get to paragraph 52 of that judgment, it then actually says, and it says in summary, and it explains a summary of what it's been saying, and it says that the tribunal did not take account, and it uses the word the fundamental test laid down by this court. But then it goes on and explains that test, and it says that test means that you must show that there must be information and evidence that it intends to provide which could not have been obtained elsewhere. So we say if that's what unique contribution means, i.e. that you've got to show perpetual uniqueness or clairvoyance, that no one else could provide that, That can't be the test. Secondly, to the extent that we, in our submissions in the intervention, we made some suggestion that we had unique insights. We meant that at the time we intervened, we had unique insights. In fact, no one is disputing that without our intervention, the problems with the Competition Commission's inquiry would not have been identified, and that before we were intervening, there was a very different trajectory in this matter. And in paragraph, we've given a full answer to this in paragraph 34 of our heads, page 13, where we explain that we set out the standard test in our heads, in our affidavits, into the material interest or ability to assist. And so any suggestions about uniqueness were simply indications that we believed at the time we intervened, we did have a unique insight. And we specifically make that point again in paragraph 41 of our heads. So we say that's what we've done. But what the Competition Commission has now done is to change the test to now make this impossible standard that you have to demonstrate that no one else could, not has, but could provide similar information or evidence. And we say that that leads to a very bizarre position, because if the intervener doesn't intervene or seek to intervene to show the problems, how would the tribunal ever know that there was something missing? It would not know what it doesn't know. And that's the fundamental logical difficulty with the approach taken by the Competition Appeal Court.
Yes. It appears to me that what the CAC did was to look at what Lewis had proposed to do or to offer. And based on that, that is now the term of uniqueness. Based on that, use that as a test. Is it allowed to do that? Or what?
Yeah, so Justice McClellan, I agree. So I think there are two answers to that. Firstly, if that is what it's done, no, you can't. It can't be that a party. So if the submission is the Competition Commission used a new test that we suggested against us, we would say, well, the test is the test. A Competition Appeal Court can't change the test because of submissions by a party unless it specifically says, I'm proposing to develop the law, which it doesn't do. That's submission A. But I have a second submission, which I haven't been making clearly, which is B. I think it's wrong. We do not, if you read our founding papers in the intervention, we do not say there's a new test. We simply do not. In fact, at paragraph 12 of our heads, we give the standard test. We say Lewis has both a material interest in the merger proceedings as well as having the necessary ability to assist the tribunal in assessing the merger. We give the standard test. So the mere fact that in parts of our discussion of what we are saying, we use the word unique doesn't change the test. But the third submission is it's beyond that, because when we use the word unique in our submissions, we meant no one else is bringing these views as to the real competition set, the real problems in the market, but Lewis. And that was true at the time we made those submissions. There's now a suggestion that, well, that doesn't matter if someone else hypothetically could do that work, or if the commission could be asked to do further work. But that's certainly not what our submissions were.
Thank you. Thank you, TCJ.
Thank you very much, Justice Mhlanhla. Any other questions, colleagues?
Yes, TCJ, can I ask?
Please go ahead, Justice Matopo. Your camera is off.
Oh, yeah, sorry. Thank you. Oopsie. Yeah. Mr. Kotsodis, is the application or misapplication of the test by the CAC not an error of law? You contend that they have developed a new test. And that development of a new test, does it amount to a misapplication of the settled test or an error of law?
Yes, it's a very good question, Justice Matopo. I think the answer is that where a court changes the test and it either doesn't know that it's changing the test or does but doesn't properly explain it, that is an error of law, because it clearly in this case says the fundamental test is X, but that isn't the fundamental test. And so we say that's an error of law because it's got the test wrong. And that's a question of law. What is the test for intervention? And when a court gets the test wrong and misstates the law, misunderstands the law, then it's an error of law, we would say. But we also might want to make the suggestion that it's a question of form over substance. And this court has always said that it's concerned with substance, not form. And the substance here is that absent the Competition Commission, the only way to understand the Competition Commission's judgment is that it had a very different idea of what the test was to the tribunal, because otherwise it would have gone into looking at all the reasons that the tribunal had given for how Lewis could assist and engaging with whether those were correct, whether those findings were correct. The only way that it didn't do that is to say, no, there's a different test. The test is there information or evidence that couldn't be obtained elsewise, including from the commission?
I'm not sure if you are aware of the two judgments of this court, one in Tuta and one in Villa Crop, which dealt with the distinction between the misapplication of the settled test and the error of law. And if you are aware, would you contend that you fall within the Tuta and the Villa Crop judgments for you to ground jurisdiction?
Justice Mitchell, I must admit I know the judgments, but I haven't applied my mind to the specific terms of them. But I would, I think my learned friend Mr. Maneche is dealing with the question of the jurisdiction, and so perhaps he may want to engage you on the question. But I would submit here that this is a very clear case of an error of law, because it's not just a misapplication of the test. They've simply changed the test, we would say. If you read paragraph 52 and you compare what they've made the test into versus what the test was under community healthcare, that's a change of test. So we would say that's a clear indication of an error of law. But I don't have the immediate paragraphs before me, Justice Matopo, so I won't suggest that I can tell you one way or the other whether we're within the framework. But my learned friend, Mr. Maneche, may be able to be of more assistance.
Okay, let's debate the merits a bit. On the intervention, is it proper to say that we have to weigh in, or a court or a tribunal dealing with an intervention, to determine whether the arguments at that stage are correct or not?
So just, could you just rephrase that for me? Sorry.
Well, Lewis is asking to intervene in the proceedings.
Yes.
Right? The tribunal has allowed Lewis to intervene, and with a view that in the fullness of time, Lewis would be able to adduce evidence why it is imprudent at this stage for the measure to continue. What I want to establish is it at this stage, the preliminary stages of an intervention, that we should make a determination whether its merits are correct or not? Or whether it has an interest.
Yeah, I understand the question, Justice Matopo. Thank you. I think this court gave the answer very well in the essay writing for the Disabled Association at paragraph 9. And we quote that paragraph 32 of our heads, and it says that the applicant does not have to satisfy the court at the stage of intervention that it will succeed. It's sufficient for such applicant to make allegations which, if proved, would entitle it to relief. So we would say that at the intervention stage, you don't have to prove your theory of harm. You have to put up credible arguments, which we have done, and we've put up credible evidence. In fact, some of it's contested, but we specifically showed on each competitor why they weren't close competitors, why they shouldn't have been included. So we gave all of that evidence. And obviously there's a dispute between the parties as to whether we're right or wrong, but that's the issue that would be determined at the inquiry. And we would say that's also consistent with Rule 46 1A of the tribunal rules, which require a concise statement of the submissions you're going to make in your interest. It doesn't require that all the evidence is put up. But we have put up evidence, and we have made allegations on affidavit. Obviously, those will be tested in due course. And that, in fact, is what the Competition Appeal Court itself said in the Sunrise decision at paragraph 19. It specifically said on that case, it was issues around whether public interest issues would prevent the merger. And in paragraph 19, it said there are disputes between the merging parties and the commission and the intervener. Those will be determined in due course, not now, not at the intervention stage.
Okay, finally, was it proper for the CAC to look into the alleged misdirections by the tribunal without considering the merits of its intervention application? In other words, you ask why all this other misdirection that the tribunals may have had according to the CAC, without looking at the real substance of the application, which is the application for the intervention. Was it that a proper procedure or proper records to follow?
I understand. Mr. Matopa, I think that's a very good point. We don't say it was. We say that it ought to have considered the substance of the submissions made by Lewis and why it said it could be of assistance. And it ought to have considered those in detail before it excluded Lewis. And we say that was for two reasons. So firstly, it would have to do it independently if it is going to exclude Lewis. But secondly, it would have to do it because in order to find that there's been a misdirection, to properly find a misdirection, they would have to have engaged with the tribunal's own reasons for making factual findings as to what Lewis had put before it in its intervention and said why those were misdirected findings of fact. It couldn't disturb the findings. And I read this court a number of findings by the tribunal as to what was before the tribunal from Lewis in its affidavits. And before that could be disturbed by the Competition Appeal Court, it would have had to have engaged with those, and it didn't.
All right. Thank you very much.
Thank you, Justice Matopo. Does not appear. Any other questions, colleagues? Justice Kolobane?
Thank you. Mr. Koutouris, the test that the tribunal followed as well would appear to be that they also embraced the proposition that the information would not have been otherwise available to the tribunal. Do you agree with that? Because that appears from paragraph 39 of the tribunal's reasons, the sort of
yes.
Gloss on the test.
So it's an interesting. It does quote it quotes an earlier judgment in 39. I know the passage well, Justice Kolobane.
The Vodacom judgment, yes.
It quotes a tribunal. So I think I'd want to make two submissions on that.
I just want to ask. Can I just finish my question?
Oh, because, sorry.
My question would be that if the information would otherwise be available, then a party's ability to meaningfully assist would be called into question, not so, if that information would otherwise be available. So I just want your view on that. But arising out of that is, let's assume the party then makes information available to the tribunal that was otherwise not available to it. Must that necessarily lend itself to the conclusion that the party should be admitted? Because, and one of the arguments that have emerged is whether the tribunal could refer it back to the commission to, in a sense, gather that information and place it before, or is it your argument that once you do that at base one, you're then entitled to intervene, notwithstanding that you've assisted at some level, but that assistance is not a ticket, as it were, to full participation ongoing? Yeah.
Thank you, Justice Kolobane. I think there are a few questions there. I'll try and address each of them. So I think the first is in relation to paragraph 39. There's a reference to an earlier decision by the tribunal in Vodacom. Now, importantly, that isn't a Competition Appeal Court decision. It's tribunal itself, and it does have this language of will assist with additional information not otherwise available. but it doesn't go on and explain what it means by otherwise available in the sense of could not have been obtained elsewise, or could not, as opposed to not otherwise available, as i.e., but for your intervention, we don't have the information.
But you accept that the tribunal framed its test with regard to information not otherwise available. I mean, that must follow, otherwise it wouldn't have made reference to that case answer.
Well, I think it does reference the judgment, but I think when it goes on and explains itself, its assessment, it sticks within the classic test, because it explains clearly how Lewis can assist. But I accept the proposition that if otherwise available means not currently before us at the time of intervention, then there's no inconsistency between the two approaches, in the sense that at the time that Lewis intervened, this information, this view of the market was not otherwise before the tribunal. So it wasn't as if this Lewis's views as to the nature of the market and its theory of harm was being presented and argued that there was a substantial lessening of competition. That wasn't being presented to it. It was being told by the Competition Commission that this merger didn't lead to a substantial lessening of competition. So its views were not before it. Now, you pose an interesting question that if the argument, if you're able to assist and you've shown that, once you've shown some assistance, could you be excluded from participation? And we would say that really would change the test, because in a number of cases, so for instance, there's an example of Sunrise, which we've spoken about. In that case, what happened was the intervener, Sunrise Energy, had said there are significant problems, public interest concerns, and the Competition Commission hasn't properly investigated those. And so we have real concerns that this merger should be prohibited on public interest concerns. Now, those submissions weren't before the tribunal. But what can't then happen is you say, well, I can now ask the commission to go do further work on this, and then I'm going to exclude you. And that certainly never what's happened previously, because otherwise Sunrise Energy would have been excluded. When in fact, what happens in the Competition Appeal Court is that they accept that because they have presented a different and conflicting view as to what will happen if the merger is allowed, they have shown the ability to assist, and they have an ongoing right to then participate to advance that view. And I think that's the real difficulty here, because if you are excluded, then effectively Lewis would not be able to advance its view, which is now contested. And the only party that would, yeah.
So, Mr. Koutsoudis, are you saying that when a party seeks to intervene, raises information that would ordinarily should be available to the commission, but for some reason, and maybe not bad fate, the commission never traversed that, the tribunal would always be precluded from referring that back to the commission, because that party has now staked a claim and should be allowed to intervene? Is that not a far-reaching proposition?
No, I don't think it's an either or, Justice Colopin. I think it's a both and. So I accept that the tribunal is always at large to ask the commission to do further work. And in fact, the commission from time to time changes its views in merger hearings. There have been cases, and one of them is famously the Sasol oil case, which we reference in our heads of argument, where the interveners come in and they take one view as to why the merger should be prohibited, and the Competition Commission takes a different view. But after hearing all the evidence and seeing how the matter goes, the commission ultimately changes its view and says, you know what, you're right, this should be prohibited. And so there's nothing stopping the tribunal asking the commission to do further work. But what shouldn't happen is that the party that has the concern and wants to advance it and prove its case should then be excluded, to say, well, we've got your basic point, and well, let's see what the commission says, but you can't support your case. We think that would be a very strange proposition, and it robs the tribunal, its truth-seeking function, of hearing both sides of that argument.
Okay, thank you. Thank you, DCJ.
Thank you very much, Justice Colopin. Colleagues, any other questions?
DCJ, may I please, a follow-up question?
Please go ahead, Justice Dambuza.
Mr. Koutsoudis, this follows on from the debate that you've just had with Justice Colopin. How then does that interpretation interface with the Commission's statutory powers and authority? You understand what I mean?
Yes, Justice Dambuza, I do. My submission is that the two can work in parallel. There's nothing stopping the Commission. The Commission has an ongoing role in this merger inquiry and will have an ongoing role. It will advance its submissions as to its views of the competition in the market, and it will support that with evidence, and it can do further investigations in that respect. But that doesn't mean that there is no value in Lewis putting up an alternative view as to why it says the Competition Commission is wrong, because the Competition Commission is a statutory body, but it's not. But no investigator is infallible, and it isn't. And Lewis is able to advance a conflicting view as to the true nature of the market. And already, the tribunal, who is the specialist adjudicator, has said that Lewis has been able to demonstrate that there were material deficiencies in the way that the Competition Commission approached assessing this market. And so
yeah, even accepting that there were deficiencies, because as I understand things, your argument now is that if a party shows deficiencies, as you argue that Lewis has done here, then they become entitled to then prosecute their case further. Now, given that the primary authority rests with the Commission, I'm just concerned that this could result in an unintended, outsourcing. The term that's used here.
Yes. I think I have two answers to that. So the first answer is that in a large merger, it's the Competition Tribunal, not the Commission, who is the specialist adjudicator, as this court said in Medical Link. So it's the decider. The Commission is an investigator, it makes recommendations. So that would be my primary submission, so that it's the tribunal who needs to make a decision. So if it has competing views, it will hear both of those views. It doesn't strip. It's not an outsourcing. Lewis is not being asked to do the Commission's job. The Commission will do its job. The tribunal says we want to hear from Lewis because it takes a different view. And in order for me to decide, will this merger lead to substantial lessening competition, I'd like to hear both views. I want to hear both.
I think reference to the Commission was an error on my part. But what I wanted to say is that if the tribunal is not able to refer back to the Commission for further investigation, wouldn't that be far-reaching, as Justice Colopin says?
Justice Dambuza, our submission is not that the tribunal is precluded from referring any inquiry back to the Commission. It can. Our point is a separate one, which is that doesn't preclude or mean that Lewis has no value to add in the submissions it wants to advance. The Commission can be asked to do further work, and it can make its submissions based on that further work. And that often happens in merger inquiries. The Commission may, in fact, of its own volition, change its views in the midst of a merger inquiry. But that doesn't mean that there's, yeah.
The reason that I'm concerned is that part of the merging parties' argument is that the information, further to being information that is additional to the information that's before the tribunal, it should also be information that would otherwise not be obtainable through the tribunals or the Commission's statutory powers.
Yes.
What do you say to that?
Well, we say that is indeed what the Competition Appeal Court has said, and we say that test is not a workable test. It's not an appropriate test, and it's not the test that's previously been applied by the Competition Appeal Court, because what that would then mean is that if an intervener such as Lewis or potential intervener comes and says, this is our understanding of the market, you've misunderstood the market, these are the flaws, and we would like to advance this, it will be kept out, even though it's been able to demonstrate its ability to assist, because the tribunal would have to then say, well, even though you've shown me what's missing, I now can go and ask the commission, hopefully, to fill in those gaps. And so therefore, I no longer require you. And we would say that then creates a bizarre position where an intervener, there's a chilling of intervention, because then you don't intervene, and then the tribunal never learns the deficiency. And in this case, it would demonstrate this. If Lewis had not sought to intervene, the deficiencies would not have been pointed out. And I would lastly, just to try and put this in a practical example, I would recommend to this court the Sunrise judgment by the Competition Appeal Court, which we've referenced in our heads, because there it's precisely the situation where the Sunrise Energy says, look, there are significant missing gaps here in relation to public interest and a dispute. We say there's a public interest concern, and the Competition Commission doesn't think so. And the Competition Appeal Court says, well, therefore, you've shown your genuine ability to assist us in the exercise of our mandate, and therefore you're in. And of course, the commission and you will have a dispute as to what the issues are. But the answer wasn't, well, we'll ask the commission to do further work and you're out. And we say that that's a very unique and new way of understanding the ability to assist.
Thank you. Thank you, Mr. Kutsotis. Thank you, DCJ.
Thank you very much, Justice Dambuza. Justice Rogers?
Yes, Mr. Kutsotis, just one question. In regard to this notion of evidence which the tribunal could not otherwise obtain, what category of evidence could notionally exist which the tribunal couldn't theoretically obtain, assuming the intervener through its application has alerted the tribunal and the commission to information? A combination of the commission's investigative powers and the tribunal's inquisitorial powers, is there any class of information which would, despite all of those powers, be beyond the commission and the tribunal? Because if there's not, then it seems to me the test of evidence which the tribunal could not otherwise obtain effectively precludes all intervention.
Justice Rogers, as the council team, we've debated exactly that issue, and we can't think of anything. So we agree with you that the difficulty with this requirement, and in fact, even our learned friends for the emerging parties accept that this requirement has been added. They say that even though they say there isn't a new test, they say the Competition Appeal Court now requires you to show that the information could not otherwise be obtained by the exercise of the tribunal or the commission's statutory powers. And as you know, as you've suggested, Justice Rogers, that includes the ability to subpoena and compel evidence and documents wide-rangingly. So there could never be a class of documents or information that couldn't otherwise be obtainable, we say. So we agree with you that effectively what this test does is to effectively make intervention impossible if it were to be applied consistently.
Yes, I suppose the exception might notionally be information from overseas parties that aren't subject to the Commission's investigative powers. And if the Commission asked for information from them and they refused to give it,
yes,
but they would be unlikely not to give it if they were wanting to intervene in the first place. Yes, thank you.
Thank you very much, Justice Rogers. Any other questions, colleagues? Okay. There's no other question for you, Mr. Kutsovides. So we're going to take the tea adjournment. It's going to be 15 minutes. I say it's 11:15. We will adjourn till 11:30. 11:31. I see it's 10, 11, 16. Thank you very much.
Thank you.
Please keep your mics and your cameras off, but don't leave the platform. Thank you.
Thank you, Deputy Justice.
Court adjourned.
Justices of the Constitutional Court, all counsel are online.
Thank you very much. Ms. Leroux?
Thank you, DCJ and Justices, and may it please the Court. Justices, I intend to address 5 topics this morning. The first is what this case is about, what it's not about, and what is at stake here. The second is the settled test for intervention and the reasons why the CAC did not create a new test. The third is correcting several of the other errors or misstatements that Lewis has made about the case and how it has unfolded. The fourth is leave to appeal, and the fifth is the relief that we seek. But Justices, let me start with 2 overarching submissions in response to the debate that has unfolded thus far this morning. The first is that the CAC did not create a new test. It assessed Lewis's intervention application against the settled test of Lewis claiming to have an ability to assist. Lewis says, I can assist you because I have insider knowledge, a unique view of the market. I am a special retailer because I am one of 3 national retailers. So Lewis says, I am special and have particular unique knowledge that I need to share with you. The CAC then scrutinizes its intervention affidavit and finds that all that its drafters did, presumably the attorneys and economists paid for by Lewis, because the deponent is the in-house legal head of Lewis, no one operational or commercial. They put up Google Maps and screenshots. Nowhere in that affidavit do you find what Lewis's insider view actually is. The CAC says, you told me you could assist because you had unique insider insights. I've looked at your affidavit and I see Google Maps and screenshots. You therefore don't show me in your affidavit this insider knowledge that you want to share. Therefore, you're not going to assist. That is why the CAC finds that they did not meet the settled test for intervention. This is not a new test. The second thing is that the tribunal order, for all of the reasons addressed in our heads and in our answering affidavits, the tribunal order is filled with material misdirection that was correctly addressed by the Competition Appeal Court. So this case is about Lewis claiming that a denial of intervention, where there is a discretion to award it or deny it, contravenes its constitutional rights under Section 33 and 34. And it says that it can never be that a competitor is denied intervention. But as I will show you, that is not, in fact, the legal position. And the CAC therefore appropriately applied the settled test, not a new test, nothing that requires this court's exercise of either its constitutional or its general expanded jurisdiction. Lewis's case is that denying it intervention contravenes its constitutional rights. It accepts, however, that intervention is within the tribunal's wide discretion. And this is because we know that the legislative scheme in Section 53 only permits intervention and participation of right by 4 categories of participants: the merging parties, the Commission, the Minister of Trade, Industry and Competition, and recognized trade unions or employee representatives of the merging parties. They have a right to participate. Anybody else, and someone in the position of Lewis as a competitor, must get leave to intervene, and it must do that by demonstrating an ability to assist or a material interest. Lewis came on ability to assist. Therefore, it assumed a burden to demonstrate that it had something that no one else could say. That is all that is meant in the CAC decision when it says you didn't in fact show that you had evidence not otherwise obtainable elsewhere. That is also the CAC enforcing Tribunal Rule 46, which requires that your interests and what you're going to say in the merger hearing is not already represented by some other party, for example, the Commission. And that is because, Justices, in merger hearings, there are 3 different ways in which a party's views can be presented in the merger hearing on the merits of the merger. The first is through intervention, where you satisfy the test of intervention. The second is where the Commission calls you as a witness and places your evidence before the tribunal in order to support its recommendation. And the third is where the tribunal, because it is inquisitorial, calls you to participate. So when the Competition Appeal Court ends its judgment by saying this is not the end of the road for Lewis, all it is saying is that, Lewis, you brought an intervention application saying that you had insider knowledge that you wanted to share with the tribunal. You only put up Google Maps and screenshots that presumably your attorneys and economists found for you, because there is no deponent with operational, commercial, trade experience. I find, therefore, that you didn't put up something that assists and won't come from anywhere else. But the Commission can call you, or the tribunal can call you. And we now know that the tribunal then convened a pre-hearing after the Competition Appeal Court judgment came out and issued directions to the Commission, which it is currently busy fulfilling, to procure more information from market participants, including my clients, the merging parties, and presumably also Lewis, as well as other firms. My instructions are that my clients have already received 3 sets of requests for information from the Commission and engaged with them. And at the end of January, the Commission will be publishing and filing with the tribunal a supplementary report on the merger, addressing the 4 topics identified by the tribunal in its reasons: market shares, the competitor set, closeness of competition between different retailers, and the constraint posed by online furniture retailers with bricks and mortar retailers. Justices, I stress that on all 4 of those topics, Lewis doesn't have the complete picture. The Commission, with its compelling powers, is in the process of obtaining a full market picture from the overall market participants, and it is busy preparing a supplementary report. Lewis would have only its view of that, and we are ignorant as to what that view is because it never put up any evidence in its intervention application saying this is who I think my competitors are because I am the store manager of Ramalema or Modemole or Flagstaff or Tsolo or Mzimkulu and all of the other 10 local towns where they identified a local market that they thought needed closer scrutiny. The CAC looked at those facts and said, you aren't helping me with Google Maps. You aren't telling me what your own internal documents say about competition and what is relevant and why the market definition by the Commission is incorrect. Lewis said, I have expertise from my decades of trading. Lewis never gave any actual expertise to the tribunal in its intervention application. But Lewis's case here is because you denied it intervention, its constitutional rights have been trampled. But it cites no case authority to support that proposition. And that is because there is none. Because what Lewis, the position that Lewis finds itself in here, it brought an application for intervention where the tribunal had to exercise a wide discretion and the CAC could similarly take a view on the facts set out in the affidavit, given the material misdirections in the tribunal's order. Lewis came along and said, this is my case. I want you to exercise your discretion in my favor. The tribunal erroneously did that. The CAC corrected that. Lewis is in the same position as litigants that lose in applications where a discretion is exercised every day in our courts. An applicant for leave to appeal loses. An applicant for joinder or intervention itself loses. It doesn't mean that its Section 33 and 34 rights have been trampled, and it doesn't mean that it should be entitled as of right to proceed to the next stage of litigation. These filters exist at every step of litigation. Every single one of them has a test that must be applied, and only if you put up the evidence required to pass that test in your application papers do you get clothed with the status here of an intervener. It is routine to lose and to disagree with the decision-making body, here the Competition Appeal Court, that denied you that status that you sought. But it is because your papers were deficient. It is not because there is some right to be there if you're in Lewis's position, because Section 53C5 makes clear that you don't have that right. And it is also not true that the court contrived a new test. So Lewis's case rests on two fallacies or two fundamental mistakes. The first is where it says that the proper adjudication of this merger in due course by the tribunal will only happen if it is there as an intervener. The tribunal hearing in due course will still be fair because the commission has now undertaken at the tribunal's direction the investigation of the 4 topics. It is preparing a supplementary report, and the possibility exists that either Lewis will be called by the commission or by the tribunal. Once the commission's supplementary report is filed, a further pre-hearing will be held, and the tribunal may well exercise its inquisitorial powers there and still call for Lewis's participation. The second fallacy of Lewis's case before this court is that it somehow deserves a reward for bringing an intervention application where the 4 areas that need bolstering in the commission's supplementary report are identified by the tribunal in the intervention decision. I say that because Lewis, with no basis in fact or law, has advanced to this court that this merger was otherwise going to be rubber-stamped in chambers. All that we in fact know about that is that the tribunal had written to the parties on the 30th of April who had participated in the commission's investigation. The court will recall that the commission investigated this merger for 7 months. It spoke to suppliers. It spoke to other competitors. It spoke to customers. It spoke to the range of market participants that you would expect it to speak to as the commission. The tribunal wrote in April to all of the parties who it found in the investigation record of the commission and asked them if they wished to participate. While it was waiting for those responses, it set down the in-chambers hearing, but Lewis responded, the only one, to say that it wished to apply to intervene to seek the prohibition of this merger. As a result, the tribunal advised the merging parties that it needed to have a pre-hearing to regulate the running of the intervention application, and that was then held on the 14th of May. So, Chair, we simply do not know, Deputy Chief Justice, we simply do not know that the tribunal would have rubber-stamped in chambers because we know from practice that often the tribunal will consider a merger in chambers and still ask questions, still ask the commission to go and take a look at more things, still ask that parties give it more information, still say that it needs additional submissions before it can make a decision on whether it approves, conditionally approves, or prohibits the merger. So it is pure speculation to say that it was otherwise going to rubber stamp. But it also means that when Lewis says, reward me here, because in the reasons on my intervention application, the tribunal said there are these 4 topics that I want to explore further, that somehow it should be found to have satisfied the test of ability to assist. And that is simply not an argument that has any legs and is sustainable. Justices, we also know that Section 53C sets out a default position on procedural rights. You'll recall the argument that we made that the default position for a party seeking intervention is that it will only be allowed to question witnesses, not call its own witnesses, and inspect documents that will be presented at the hearing, not call for its own discovery. We know from the Northern decision of the Competition Appeal Court that an intervener must then argue for every additional procedural right that it wants. It must explain why it needs discovery, why it should be allowed to call its own factual and expert witnesses, why it should be allowed to lead expert evidence, why it should be allowed to make argument. Because justices, in the tribunal process, because it is inquisitorial and not adversarial, parties come and make submissions to the tribunal routinely. They don't necessarily get to discover documents, call for documents, summon witnesses, lead their own experts, cross-examine everybody, and make argument. They merely provide further information and input into the tribunal's deliberation on the merger. So Lewis misstates Northern. They invert the way Northern works. Lewis contends that Northern stands for the proposition that an intervener gets full procedural rights unless the other side can show that it shouldn't. But in fact, Northern stands for the opposite, that where you come in with a theory of harm that requires you to have a right to get discovery or a right to cross-examine, you argue for it, and then one by one, you accumulate procedural rights. So in Northern's theory of harm related to third parties, junior minors, not itself. It therefore said, I need the power to get discovery from those entities and summon them as witnesses because it's not in my personal knowledge how junior minors operate. Therefore, the CAC said, you can ask for discovery, you can call witnesses, you can cross-examine people. Here, what Lewis has done is said, I, Lewis, am special, unique because I've traded for decades in the furniture retail market. I have unique and insider view to give you, but the tribunal gave it all of the powers that the commission would otherwise exercise. That is one of the material misdirections here. The other thing to disabuse the court of, because it features in the way that this morning's debate has developed with respect, is this idea that there are competing versions that must be reconciled or disputes of fact that must be resolved by the tribunal in merger hearings. There is not a dispute of that nature. There isn't a list that must be resolved by the tribunal. Lewis says the actual merger inquiry is the dispute. But that, with respect, is a nonsense, because the way this works in the tribunal, because it is inquisitorial and because it is made up of economists and lawyers, is that the tribunal panel must analyze the evidence on the merger and come to a conclusion on two tests. Is the merger justified on competition grounds, and is it justified in the public interest? The intervener doesn't have a right that is being determined by the tribunal, in this case, to have the merger prohibited as Lewis seeks. It has a right to participate if it has established an ability to assist the tribunal in the tribunal's adjudication of here, the competition leg of this merger test. It is not litigating a claim against the merging parties or the commission for its conditional approval of this merger. It is merely here to say, this is my view of the market, a view that we have to say is unique because only Lewis thinks that this is a three-player market, that the merger causes irreversible harm to competition if it is permitted. Only Lewis holds that view. It's unique in that sense. It's wrong on the merits, of course, but that's not for today. But the intervener does not have a dispute that needs to be resolved. And so when the tribunal itself adopted the incorrect test, it's not the Competition Appeal Court that applied the incorrect test, it's the tribunal. Because the tribunal adopted a test that said, I can't reconcile the views on, for example, market shares by the merging parties and the commission in its report and what Lewis tells me. And therefore, I must let Lewis in. No, what has happened now with respect, is the correct legal position. The Commission is busy getting better market share information from the entire market, including the merging parties and presumably including Lewis, but other retailers as well. And the Commission is having another look at that issue and putting a supplementary report before the tribunal for its consideration by the end of January. So this is not a bilateral dispute that needs to be resolved. It is simply an inquisitorial process in which parties with views that the tribunal wants to hear will participate. And Lewis, as I've now said repeatedly, is there because it's in the Commission's investigation record. It is there because it will be dealt with in the supplementary report. And it can be there if either the Commission or the tribunal call Lewis as a witness at the hearing. So Lewis has not been silenced or excluded. It has just lost an intervention application. It doesn't have that packaging, that status. It is in the same position as every other litigant who routinely finds itself on the losing side of an application. And this court has repeatedly held that disagreeing with the results that you get does not engage this court's jurisdiction either constitutionally or on the expanded basis. But justices, there is a more concerning difficulty with what Lewis seeks in this appeal. Because if this appeal is upheld, Section 53C5 is essentially meaningless. Competitors will be allowed in on the flimsiest of intervention applications, which is what Lewis's application actually is, as I will show you in due course. Future merger hearings will be overrun by competitors pursuing a commercial self-interest to delay, distract, and derail from the tribunal's expeditious adjudication of mergers. But if Lewis is allowed in and given all of the powers that the statute and the legislature gave to the Commission and to the tribunal, this appeal, if it goes Lewis's way, also damages institutional independence in an irrevocable and irredeemable way, because it is assigning the public powers that the Act gives to independent regulators to the private lawyers and economists paid for by a competitor. Because I must stress this practical reality in merger hearings. Because of the confidentiality and the commercial sensitivity of strategic documents, internal marketing plans, internal operational materials about how firms compete against each other, only the attorneys and economists of Lewis would be able to see that information. A Lewis store manager or a Lewis buyer of furniture or a Lewis CFO or CEO, someone who actually has the commercial operational trade experience that Lewis touts but hasn't put up, that person will never be allowed to see the sensitive commercial information of my clients or of any of the other retailers that the Commission has now obtained information from. Additional information, because it already had it from the initial investigation. So what this appeal will actually do is permit competitors with deep pockets to pay for external lawyers and external economists to mark the homework of the Commission's lawyers and the Commission's economists, because that is actually all that Lewis did in its intervention application. The drafters of its affidavit pointed out shortcomings in the Commission's report. Now, justices, we all know that we can all spend billable hours looking at reports and find things that could have been done differently or could have been done better or could have been done more comprehensively. That is all that Lewis's attorneys and economists did. And so what is at stake in this appeal is whether this court, with respect, will permit the privatization of the Commission's work by its lawyers and its economists to external private lawyers and economists paid for by competitors who have a commercial self-interest to delay, distract, and derail merger hearings. And this matters because merger control matters for economic growth. Economic participation in the South African economy, jobs that flow from it, business opportunities that flow from it, mean that the South African merger control regime cannot disincentivize that kind of investment that comes about because of merger activity. Allowing competitors of merging parties to intervene on the flimsiest of bases like this, and allowing them to come in effectively as of right, and so that they can pay lawyers and economists to do the Commission's work and mark its homework, even when they fail to actually set out evidence that satisfies the test of an ability to assist. Mergers will become even less attractive in South Africa because of the delay and the cost that will arise. It especially means that this is a problem because a private party can always find more lawyers and more economists than the Commission's scarce public resources can afford to pay to investigate every merger. And that is what is at stake in this appeal. More specifically, the appeal seeks the restoration of an unlawful and irregular order. You will note that in its founding papers, in this application for leave to appeal, in its written submissions, and in the address today by my learned friends, Lewis doesn't even begin to defend the material misdirections and errors made by the tribunal in its order. You get a bit of an argument about, oh, put some purposive glasses on and you can read it in a way that isn't that bad. But there are so many material misdirections in this tribunal order that the Competition Appeal Court had an obligation to intervene and correct those in order to ensure that justice was done here. That is all that happened here. So if we actually look at that tribunal order, we will see the various mistakes. The tribunal order you will find on case lines in volume 12, part 2, sorry, page 2 of part 12. Paragraph 1 grants intervention. Paragraph 2 says, I recognize you as a participant in terms of 53C5, and says it's subject to the scope of intervention in paragraph 4, which I'll get to. Paragraph 3 is then the first material error made in the tribunal order that the court correctly corrected. Because there, the external lawyers and economists are given access to the entirety of the Commission merger record. Yes, subject to confidentiality undertakings, but including documents on public interest or topics that Lewis didn't even say it would assist on. Because the Commission's merger record obviously includes all factors that are relevant to the Section 12A merger test. So paragraph 3 is a material misdirection by the tribunal. It gave access to everything, including things that fall outside of Lewis's own requested scope of intervention. Paragraph 4 then purports to set out a scope of intervention. It says you can have market definition with respect to the market for the retailing of household furniture products. Now, that does at least get rid of beds and mattresses and credit as a separate market. But then in paragraph 4.2, the tribunal gives Lewis the opportunity to explore every single factor listed in the open list set out in Section 12A2 of the Competition Act. So it gives it the right to explore things like import competition, ease of entry, history of collusion, vertical integration, and other mergers engaged in by the merging parties, even though Lewis never asked for that. A material misdirection is obvious where a tribunal grants something that you didn't even ask for. And it gave you everything, which is the statutory function of the Commission and the tribunal. It is the Commission and ultimately the tribunal that must assess all the factors listed in 12A2 to determine whether there is a competition justification for the merger. But it gave it all to Lewis. That is the very essence of privatizing that public power. 4.3, it gave it remedies in respect of market definition, and again, all of the competition test, including the topics that Lewis didn't even ask for. So the court will know that this transaction was conditionally approved. Well, it was recommended for conditional approval by the Commission. Lewis is entitled under paragraph 4.3 of the tribunal order to weigh in on all of those remedies, including on topics it wasn't actually awarded. Paragraph 5 then purports to set out the procedural rights, but again, without any limitation and with no justification in the reasons that the tribunal subsequently published that comply with the Northern framework of looking at the theory of harm and ascertaining whether you needed the particular procedural right. But instead, it gets given all of the compulsion powers that the Commission and the Tribunal have under the Act. It can summon a call for discovery from the merging parties, the Commission, and anybody else. It can request summonses and the compulsion of oral and documentary evidence from anybody else. It can adduce evidence, including through its own experts. It can cross-examine everybody, and it can make oral argument and written argument on everything. As I've already said, the tribunal, in its inquisitorial adjudicative role in merger hearings, often hears from parties, but doesn't let them produce their own evidence, cross-examine everybody, bring their own experts, and therefore second-guess the Commission's recommendation and the work that its economists and the factual information that the Commission considered in its recommendation.
Ms.
Now,
Leroux?
paragraph, yes.
Ms. Leroux, your time is up.
Thank you. Thank you,
You still
DCJ.
want
If I could just,
two more
if
minutes?
I could complete, yes, if I could complete the
Please.
tribunal order misdirections. Paragraph 6 does say that confidentiality regimes will apply. But that, for the reasons I've already explained, is what causes the privatization problem here. Because only the attorneys, counsel, and economists paid for by Lewis will get to see that information and mark the Commission's homework. The tribunal is then not getting the assistance of Lewis. It's getting the assistance of the attorneys, counsel, and economists that Lewis can pay for. And that is not Lewis's ability to assist in intervention. Paragraph 7, I was relieved with respect to here this morning, doesn't seem to be bearing the same argument that it has so far in Lewis's case. Because Lewis says paragraph 7 means the tribunal can revisit scope of intervention. But of course, that is a nonsense. Not only does the tribunal disavow this in its own reasons, but paragraph 7 is about timetabling and deadlines. It is not about the scope of intervention that is being challenged, that was challenged in the appeal that the merging parties brought. So the effect of this tribunal order, with all of its material misdirections and errors of law, is that it gives Lewis what it didn't ask for. It says it denied Lewis things that it in fact gave through the way the order is framed. It contradicted itself by denying scope, but then giving procedural rights and access to, for example, the record. And given the confidential nature of the information that's going to matter at this merger hearing, it effectively awarded the private attorneys and economists paid for by Lewis the powers of the Commission and the Tribunal. And Lewis's silence in defending the terms of the order before this court, we say, is deafening and is significant.
Is that it?
Deputy Justice, that completes on the order. I did want to then move on to the test, but obviously if there are questions, let me entertain them.
I'm sure there will be questions. What the tribunal is doing now, subsequent to the CAC order, does it not go back to what Lewis initially said? Not the tribunal, man, the commission. That the commission's report is flawed. It's missing in a number of respects, and that it, as Lewis, had the ability to assist. Can one read that into what's happening?
Deputy Chief Justice, there are two important submissions in response to that question with respect. The first is that we will never know if the tribunal would have still identified the four areas that it wanted assistance on, that it does set out in the intervention decision. We will never know if it would have still identified those 4 topics in its in-chambers consideration of the merger. That does happen. The tribunal assesses what's there, And if it identifies things that it wants more assistance on, it directs the Commission to do that. The court can know that from the Vodacom LTEC case that we put up in our submissions. It is routine for the tribunal to ask for more. So the first answer is, you cannot say that it is because Lewis intervened that the tribunal identified the 4 topics that are now being explored. The tribunal may well still have identified those 4 topics when it considered the merger in chambers. That's the first answer. The second answer is that as we sit here today, for this court's purposes, we know that the tribunal directed the Commission to go and use its compelling powers and get information from a whole range of market participants and supplement its report by the end of January on the 4 topics. So we know that as of today, that work is being done. So Lewis doesn't get to duplicate that work the way it keeps on wanting to do with its lawyers and its economists, because the court must take account of the fact that it is now happening by the Commission. And the third point on this, equally important, is this. When an intervener says, let me come in as an intervener, it has to demonstrate an ability to assist. That ability had to rest on Lewis's claim that it had insider knowledge, an inside view, unique insights, which is what its founding affidavit in the intervention application keeps promising. It cannot say, my attorneys and economists are really good because I pay them a lot, and they will come and assist you by marking the Commission's homework. That is not Lewis providing evidence to the tribunal of assistance to it in determining whether the competition test is passed. That is not the ability to assist that an intervener should demonstrate. So Lewis is still knocked out here because all that its founding papers show in the intervention application is that the drafters of the affidavits could do screenshots of Google Maps. It doesn't show that Lewis is assisting. And so for that reason, Lewis again can't claim that it should be rewarded with intervention status when it hasn't shown an ability to assist. So those are the 3 reasons why we say what has happened since the Competition Appeal Court judgment is not a reason to uphold this appeal.
Thank you very much, Ms. Leroux. Colleagues, any questions?
DCJ, if I may.
Please go ahead, Justice Majid.
Ms. Leroux, I must at the outset say I'm taken aback by the fact that you are concerned that we may be laboring under misapprehension of that there's a list here, that there's disputes of fact that need to be resolved. Can you point to questions that give you that kind of impression by the bench, that gives you the impression that we're under the impression that there's a list here that needs to be resolved, or disputes of fact, as opposed to the test for intervention?
Justice Majid, as I understood the debate...
Or did I misunderstand your submissions?
Justice Majid, I think you might have, so I welcome the opportunity to clarify. My submission was this. Lewis argues, and argued this morning again, that when the tribunal granted it intervention rights, because the tribunal said, I've got irreconcilable differences here, I've got competing versions that need to be resolved in the merger hearing, therefore, because you are one side of that fight, as Lewis, where the merging parties and the Commission are purportedly on the other side of the fight, therefore the tribunal says, come in on that basis. My submission was, that is the incorrect test here. So the Competition Appeal Court applied the correct test by saying, can you assist? What did you put up in your founding affidavit in the intervention application? You didn't put up anything that shows me your insider knowledge, therefore you're out. But it's in fact the tribunal that established a test about, is there a dispute here? Is there a list that needs to be resolved? And on that basis, you come in as an intervener. Justice Majid, that was my submission, that Lewis appears to say the tribunal set up a disputes test. And if that was so, then the tribunal again is the one that is incorrect in law, not the Competition Appeal Court.
All right, I think I misunderstood you then. Can I ask you to have a look at, or before I go there, I'm going to ask you to look at the CSC judgment shortly. But can I ask you, why do you call this a Google Maps desktop exercise? Surely what that Lewis stores had done here is to gather statistical data and information, to show that there are only really three major competitors in a national space. In some towns, there's only one of your clients, like the really far-flung towns of our country. And B, to show that there's the issue of closeness of competition, which we know is very relevant here, and that this merger may possibly lead to anti-competitiveness. So they give the statistics and data, and they say that also importantly, which I have a problem with the Commission's way of working, is you must compare apples with apples. You can't compare these with institutions like, for example, At Home or Patio Warehouse and so on. So how is that a Google Maps desktop exercise? I don't understand that. It seems to me, and correct me if I'm wrong, that's just trivializing the scope of the intervention.
Justice Majid, thank you for the question, and DCJ, with your leave, I would like to spend some time on this because this is a very, very important issue, and I'm indebted to Justice Majid for the opportunity to clarify this. If you look at the founding affidavit, and if we start this exercise,
can you take us to the record, please, when you do that?
Yes. So if we look at the founding affidavit in the intervention application, it's at case line 011.1, page 6. Paragraph 1 of that says, Mr. Lepart, who is the head of legal, is the deponent. He is not commercial or operational. He is not a store manager. He's not a buyer. He's not in marketing or sales or customer relations. He is not a retailer. He is an in-house lawyer. First point. Then we see at page 9, paragraph 19, page 7, paragraph 4. Lewis promises that it will be able to assist, paragraph 4, paragraph 5. It says, my theory of harm here is that there is a 3-player national market. That 3-player market is Lewis, Pepkor, and Shoprite. No one else matters in that market. It's a 3-player market. My theory of harm that I want to ventilate is that this is a 3-to-2 merger. Structural change, you heard it this morning. The first point to note is that closeness of competition is not the same thing as a 3-to-2 merger. Because closeness of competition says there are a range of players in this market. And depending on what product we're talking about, because it's about differentiated products in this market, there may be closer or more distant competition. There may be stronger or weaker competitive constraints. So when Lewis concedes this morning that closeness of competition is the test, is the issue that needs to be interrogated here, closeness of competition contemplates more than 3 players. And Justice Majid, to illustrate the point, you heard today about Patio Warehouse or a luxury retailer with an expensive armchair. What is going to matter here is that when a customer is choosing a particular kind of furniture, when the customer is deciding, I want patio furniture, Patio Warehouse may well be in the competitive set, and the closeness of its competition.
May I interrupt you here? May I interrupt you? I'm sorry for doing this, but for the sake of debating this, I have to. Do you accept that the market specifically that we are engaging with here are low to middle class furniture buyers, or you don't accept that because that's what Lewis's case is?
Justice Majid, with respect, what Lewis's case is it's lower to middle income and sometimes even higher income consumers, because their case ranges from LSM 4 or 5 all the way up to LSM 7 or 8. So it is not only low-income consumers that Lewis's case addresses in its intervention application. It is lower-income consumers, middle-income consumers, and even what are considered higher-income consumers. Justice Majid, the point on the closeness of competition argument is, though, that depending on what furniture you are looking to buy, a luxury retailer armchair may well be what you are saving up for and willing to go and buy because you plan on sitting on it for the next 20 years. So the nature of the differentiated products in the retail market for furniture means that you cannot say the only players here are Lewis, Shoprite, and Pepkor's furniture brands. There may be someone who is looking for kitchen furniture or patio furniture or children's nursery play furniture. And the range of who is in the competitive set will then differ. There may be an independent retailer that specializes in, desks and bookcases. And then that specialist independent retailer may be in the mix. But Justice, there's another important point on this competitor set, and it's this. Lewis's case is that there are only 3 that are in all 9 provinces. But it never explains why being in all 9 provinces is the thing that defines the market. Because there are large chains that are in many provinces. They may be in 6, 7, 8 provinces. They just may not be in all 9. And Lewis contrives a market definition so that it's only it and the merging parties. But it never puts up evidence in the intervention application that says why the large chains that populate the malls around South Africa, or the regional chains, or the independents that may have a store in that same shopping mall in a particular town, why they are not also part of this competitor set. And they may be a stronger or a weaker competitive constraint. They may be a closer or a further away competitor, depending on which furniture you're looking for. But they have to contrive a 3-player market so that they can come along and cry the war cry. And it's no more than a war cry and a slogan of 3 to 2, 2 to 1, merger to monopoly. This is definitely anti-competitive. They first have to contrive the market definition that they're looking for. But when they tell you today and in their papers that closeness of competition is actually the inquiry, they concede that it is not a 3-player only market. If you're saying closeness of competition is the issue, then you include entities other than Lewis and the merging parties by definition of what closeness of competition means. That's why in markets with differentiated products, market definition is not as precise as it might be in single product markets, because the competition authorities recognize if you're looking for a certain kind of furniture, if you're looking for a side table or, a chair that doesn't cost terribly much, it may be a different inquiry. But if I'm saving up for my new dining room suite, I may go shopping somewhere that, isn't on my main street. I might look online and see that there's something I'd like to have delivered to my town. And Lewis
I get the point, Ms. LaRue. I'm very conscious of time. I get the point you're making. But getting back to this desktop exercise, you were still continuing to explain to me why this is a desktop exercise. I got the first point. Yes. This is the head of legal attesting to the affidavit, and then you pointed us to paragraph 4. Anything else?
Yes.
On the desktop argument?
Yes, indeed, Justice Majid. Let me go there. So in paragraph 5, Lewis says it will assist because it's a national retailer actively involved for many years, uniquely positioned to assist. It's going to provide insights and evidence about the nature of competition and how the merger will affect that. So it says, I have special knowledge for you. Paragraph 16, I'm a long-standing market participant with material knowledge of and unique insights into this. Paragraph 17.2, I will explain why other firms don't matter, only I matter, because of a national offering. Then we start the desktop exercise. So up until paragraph 20 of the affidavit, Lewis has only set out propositions, not evidence. It hasn't said, here is a pricing analysis of my own prices that show you why there will be price increases. Here are my supply contracts and why I tell you I'm going to get more expensive products and have to charge more. Doesn't put up any evidence. It gives you theories, speculation. So then let's look at the desktop exercise. Starts on page 17, figure 1. There you see a screenshot of all the Pepkor stores in South Africa. Figure 2, page 18, all the Shoprite furniture stores in South Africa. Figure 3, and I stress this, you put figure 1 and figure 2 together, and you see all of the dots in the country for all of the merging parties. Then from page 20, paragraph 36, the drafters of the affidavit just start taking pot shots at the report. They identify shortcomings in the report. This is the point about privatizing the power. External lawyers and economists saying we could have done a better job here than the commission did. Then we get to
I have questions about that too, but let's continue for now with this.
So then we get to page 32. Figure 4, you see all of Lewis's stores in South Africa. And then from page 34 onwards, figure 5, Patio Warehouse. Figure 6, Metro Home. Figure 7, Fernmart. Figure 8, Mr. Price Home. Page 35, figure 9, Deco Fern. Figure 10, Hirsch's. Page 36, figure 11, Shoppers.
I get the point, thank you. I'm trying to cut this short.
Carries on, all the way to page 42.
Sorry, Ms. LaRue, I'm sorry to interrupt you. I get the point. What's wrong with putting up these comparative tables? What do you say they should have made as averments regarding this point? Instead of putting up these figures and tables.
Yes, let me make 2 points in response to that. The first is there is no figure 23 where all of the 22 preceding maps are put on top of each other, because that is in fact the furniture retail market that matters here for closeness of competition. So what Lewis does in all of these little screenshots that the drafters of the affidavit pull together is they say, look, there's only a Deco Fern store over there and a Fashini Group over there and a Fair Price over there. They never give you a figure 23 of all the dots of the merging parties, Lewis, and all of these other entities. That is the market that matters for closeness of competition. So they never show you that. And then when in paragraph 82.1, they set out the towns that they're concerned about. Again, this is because they don't do that exercise and they don't take account of independence and regional chains, which the commission takes account of. Justice Majid, the second answer to your question is Lewis needs to put up its own view. It promises you its unique insider view, but it never gives you any evidence of what that insider view is. It never says, my store manager in Ramalema says there's nowhere else to buy a dining room suite except the merging parties or us. There is no one else in town. Or Tabani, or Mzimkhulu, Flagstaff, Monemole, Tsolo, Emoyeni, Manguzi, Eshawi, Mandini. You don't see their own marketing materials that only reference Pepkor and Shoprite brands. I would suggest that their internal marketing materials probably do talk about these other competitors that are listed in all of the 22 figures, because they are in the market. They participate, for example, in Johannesburg, where national pricing is set. So their internal documents probably don't support their 3-player market. Otherwise, they would have put them up and said, look, here are all my marketing plans for the last 10 years. I only ever worry about what specials are running at Shoprite and Pepkor brands. I never look at anybody else. You never see financial information or contracts with suppliers, because we know that they say, oh, there's this problem with suppliers here. We're not going to get the same kind of good prices. Therefore, prices will go up. They never say to you, look, here's a supplier contract that I've got where they're already threatening me with price increases. That is the kind of evidence that in other intervention applications, the intervener puts up. It says, I tell you, I've got something special to me to tell you. This is what it is. Instead, you get a bunch of Google Maps with some dots on them. Then in the replying affidavit, and you'll find that, and particularly the figures that matter here are 011.2- page 13. You see figure 1, price comparisons of lounge suites. Now, Justice Majid, what you see in that diagram, which has all the colors of the rainbow and all the shapes in geometry, is that there are a bunch of players selling lounge suites. Now, the ones that clump together at the bottom of figure 1 in the replying affidavit may be closer competitors, but they're not only the 3 players that Lewis contends for.
I get the
page
point.
14, figure 2, sorry, page 15, figure 3, you start seeing these shots of 3-seater sofas and the like. This is that whole point of, if I'm looking for a 3-seater sofa, I might go looking beyond the stores in my main street. And that is the closeness of competition point. So that's why we say affidavits don't give you inside knowledge. They don't give you
assistance. I understand. I think you've made the point abundantly clear now. What you say is that there's no new... I've got 2 more questions. The one concerns the judgment and this thing of you saying they're taking pot shots at the commission. I want to get back to that. But let me first ask you this. If you say there's no new test developed, in fact, by the CAC, and the test is correctly applied, are you able to assist, which is the ground that Lewis Stores came on. The tribunal now assesses all of this and exercises its discretion. What's wrong with that exercise of that discretion? And on what basis can the CAEC interfere with this exercise of a discretion of a specialist body like the tribunal? I mean, you talk about all of this, the evidence that was put up and so on. But what's unjudicial about the exercise of that discretion? Bearing in mind this is a specialist body.
Justice Majid, there are three answers to that. The first is that we know from Justice Rogers' decision, as he then was when he sat in the Competition Appeal Court in Emery's, confirmed by this court in Mediclinic, that the Competition Appeal Court, which itself is a specialist body, can interfere and intervene to ensure that justice is done where there is a material misdirection or the tribunal is clearly wrong. And we say, for all the reasons I've already shown you, that this order is plainly filled with material misdirection or is clearly wrong, because it gives Lewis things it didn't ask for. It says it denies things that it in fact grants. It gives access to a record on everything. And most importantly, it gives Lewis all of the powers that should be exercised by the Commission and the Tribunal. So it does not, in fact, confine it to a scope of intervention. In the Tribunal reasons, you see the four issues: market shares, competitor set, closeness of competition, and online constraints identified by the Tribunal. But it gave Lewis everything. It didn't give Lewis those topics. And there's an important second point to be made about those four topics in answer to your question, which is Lewis doesn't have the information and the knowledge on those four topics. It has a piece of that puzzle. But all of the other retailers and all of the other market participants that are now being canvassed again by the Commission actually complete that picture. And it is only because the Tribunal didn't follow Northam and just gave Lewis all of the procedural rights that the Commission has. It didn't just give it the right to question and inspect, which is what the statute has as the default position. It gave it everything, saying, Lewis, go and do the Commission's job and get the information from all of these other retailers to tell us your story. And that,
may I interrupt you again? Is the answer then, if they gave it them too much, not to trim the order, not to say you can't intervene at all? You trim the order a la Northam.
Justice Majid, with respect on relief, our submission is this. Given the deficiencies of the founding papers and the replying affidavit in the intervention application, the screenshots that I've shown you, that is all they put up, and that can never meet the test of ability to assist. Because if that meets the test for ability to assist with that's
another point.
Information,
that's another point. If we are not with you on that, I'm asking you this. Just hypothetically, if we are not with you on this argument that they haven't shown an ability to assist, just for argument's sake for now, if we are not with you, then what about the order then? Is the answer not to trim the relief in line with what, for example, Northam, than to say you can't intervene at all? Would you accept that on a hypothetical basis? I understand what your case is and you're representing your client's interest.
Justice Majid, in the hypothetical scenario that you sketch, where the court is of the view that the screenshots are enough of an ability to assist, and we know that the tribunal says, I need help on these four topics, then at most, Lewis would be able to put its piece of the puzzle in front of the tribunal. But the wider procedural rights of getting the complete picture can never be given to Lewis. It can never get the right to cross-examine. It can never get the right to call for discovery from third parties. It can never get the right to lead its own expert. It can only give its own factual evidence about, I am the store manager, I am the marketing manager, I am the CFO who deals with suppliers, and this is why I say this merger is bad. It cannot take on the role that the tribunal awarded to it and said, go and investigate the whole market and tell us what your lawyers and your economists think the Commission should have done.
All right. Yeah, thank you. I want to give my colleagues time to ask questions as well. Last question. Coming to the CAC judgment. Now,
Yes.
I'm looking at paragraph 61 of the Competition Appeal Court judgment.
Yes.
I'm not exactly sure where it is in the electronic record. I know that it's 012-49.
01249.
You've got it? You've got
Yes.
it, okay. Now, it seems to me bizarre. Maybe I shouldn't put it as I. It seems to me strange that you have an intervener, a potential intervener, come before the tribunal and say, listen, the commission has been deficient in X, Y, Z in its investigations. And then the tribunal says, yes, it seems to me you've got a point. Therefore, I grant you the right to intervene. Merger parties appeal, and the CAC then says what it says is paragraph 61. While the tribunal's got to do, it's got inquisitorial powers, it is entitled to summon the respondent, that's Lewis, to appear before it. And it says later on, this is what must be investigated. These are clearly matters which clearly represent the kind of investigations that should be undertaken by the commission. It has now been alerted to the type of investigation which the tribunal requires. Why does the tribunal require it? And the reasons provided by the tribunal, because that's what Lewis put before it. It seems to me, I don't want to say bizarre, it seems to me quite strange that you could then say, well, and this goes back to what the DCJ has asked you in the beginning. Well, now the commission is actually doing it, so what's the problem? I mean, Lewis doesn't have to intervene, and you're denying them all these rights that you've just said now, right to cross-examine, call witnesses, and call for discovery, etc. It seems to me a quite strange way of doing things to say, on this basis, the problem is solved. What do you say?
Justice Majid, I say three things in response. The first is, this is a question of packaging. So what paragraph 61 says is Lewis has something to say to the tribunal. What packaging does it come in? Does it come as intervener with all of the rights and powers of the commission? We say no. Can it be called by the commission? Yes. That is what the commission is now doing, getting information from parties, including Lewis. Can the tribunal call it? Yes. So there are three lanes on this highway that Lewis could be in. And all we're saying is lane one, intervention, is closed because your intervention application didn't meet the test of an ability to assist, and we're not privatizing the powers and giving them to you. So all paragraph 61 is saying is you can still come in the other two lanes. The commission can drive you or the tribunal can call you. That is all that paragraph 61 is saying. That's the first answer. The second answer is with respect, it's not bizarre given the nature of the inquiry in front of the tribunal. So the tribunal wants to have this full picture of this market because the tribunal, and I believe it's paragraph 52 of its decision, I'm not sure, the tribunal expressed skepticism in the intervention decision where it says, I think it's unlikely this is a three-player market only, the way Lewis contends, and I think it's also unlikely that everyone constrains everyone for all products and in all ways. So the tribunal's antenna are already up, and it says, I know I'm in a closeness of competition world, and Lewis has something to say because it is a national retailer. It's not unique and special and the only one that matters in the way that it wants to craft, but the tribunal says, I need to understand this full market, and Lewis is an important player there. Doesn't mean it gets to come and do the commission's work, though. And the third and final answer on paragraph 61 is that it's also the court reminding the tribunal that it is not a passive recipient of adversarial contest in front of it like it can be in enforcement cases, which are much more like a trial. The nature of a 12A merger inquiry is to see whether the tribunal is satisfied that competition justifies this merger going ahead, or the public interest justifies this merger going ahead. So it's also a paragraph that reminds the tribunal that it's inquisitorial, it is in charge, it must call parties that it needs to hear from. It doesn't mean delegate the commission's powers and part of your own powers to a private set of lawyers and economists. So those are the three points I would make about what section 61 means.
I've completed my questions, but I must just clarify and correct you to say that in paragraph 52, the tribunal doesn't just say that it doubts whether it could be only three competitors. It says in the very next sentence, however, it appears just as unlikely that every single retailer of furniture constrains the merging parties as they have argued, and then say they've got a problem with that. DCJ, thank you. Thank you, Ms. Leroux. Thank you, DCJ.
Thank you very much, Justice Majid. Colleagues, questions? Justice Matopo, you asking a question?
Yes, may I, DCJ? Thank you.
Please go ahead.
Ms. Leroux, apropos paragraph 61 of the CAC judgment, perhaps let me take you back asking the following question. What would have happened if Lewis had not approached this court on urgent basis, taking into account the timelines that we've sketched of the end of January? What would have happened to Lewis' position?
Justice Matopo, the answer is in the directions issued by the tribunal after the Competition Appeal Court judgment came out. So the CAC judgment came out, and then the tribunal convened a pre-hearing. At that pre-hearing was the commission, the merging parties, and Lewis was present. And the tribunal then crafted a set of directives to the commission and said, go and get me the information that I need on these 4 topics. So if Lewis had not come to the court, and Justice Matopo, you'll find those directions, it's case line 001-203. It's annexure PMG5.
So let me interrupt you. If they had not come to the court,
yes,
they would have to rely on what? On paragraph 61, and that they be invited to come and present evidence. Is it correct?
Yes, well, Justice Matopo, the other 2 lanes on the highway are what have happened.
But
you
let me get...
don't have to speculate. We know what has happened. The commission has asked for information from all parties, and we presume including Lewis, and the tribunal has, I'm going to have another pre-hearing where it may invite...
I'm with you there. I'm just testing the proposition and the rationale for Lewis to approach this court on an urgent basis. And I'm asking, the question is, if Lewis had not approached this court, right?
Yes.
Taking into account the fact that the tribunal had asked for further and additional information, what would have happened to the position of Lewis?
Justice Majid, we know what would have happened. It would be a recipient of request for information from the commission that it has to answer, because the commission has compelling powers and a party must give the information requested, and it will be invited to the pre-hearing that the directions end with, which will be held after the report comes in end of January, and then the tribunal or the commission could say to Lewis, we want you to participate in the merits hearing now of the merger. So Lewis's view would still be there, either called by the commission
as what? As an interested party, but not as an intervener.
Exactly. So as a participant, so for example, the tribunal or the commission could lead the evidence of an independent retailer as well. They could lead the evidence of a furniture supplier to the retailers of South Africa. Those people aren't interveners with rights to do the commission's job.
They're participants.
They are relevant to the inquiry, and therefore they are called by the commission or by the merging parties or by the tribunal, so that the tribunal gets a full picture of what matters in this merger and in this market. So Lewis would be there, either called as a witness by the commission for its recommendation or called by the tribunal because it has an important view that must be shared. So Lewis is not shut out, it's not excluded, not silenced. It will be there, and it'll be able to say, this is a 3-player market and don't listen to anybody else who tells you otherwise. It just won't be there with the commission's powers.
If you don't mind, I can just interrupt you for the sake of progress. Do we know, or I may have missed it, that Lewis was invited? Was Lewis invited to the forthcoming hearing in January?
Justice Matopo, Lewis was at the pre-hearing that the tribunal held. It was invited to that. At that pre-hearing, the tribunal told the commission to go and ask for information from the market. We assume that includes Lewis. It certainly included my clients, and we know that it included, I'm instructed that it included other retailers. And then once the commission is doing, so what's happening in January is the commission is filing a new supplementary report with all the new information it's gathered on the 4 topics. Then the tribunal will have another pre-hearing. And I'm 100% sure that Lewis will be invited to come to that pre-hearing. And once we know what the commission's new report says, then either the commission will say, I want Lewis to come to the merger hearing in due course, or the tribunal will say, at the merger hearing, Lewis, I'm going to give you some time to present your view as well. So Lewis is still going to participate.
And if Lewis is, after participation, if Lewis is dissatisfied with the outcome of the tribunal hearings, what recourse or what remedy does Lewis have?
At that point, Lewis would, it could go to court and try to review the tribunal hearings and say, you ignored what I told you, it was relevant, you failed to take it into account, or you did something otherwise incorrect as the tribunal. So it could run a review and say, I have some status here. That is what it could do if it was unhappy. It could run a review of those tribunal proceedings and say, you didn't listen to me properly.
But
the fact that it doesn't have intervener status doesn't matter for that.
But could a defense of res judicata be successfully raised against it at that stage?
Justice Matopa, I haven't contemplated this or considered this too carefully, but no, not because it doesn't have a list against, this goes back to the dispute point. It doesn't have a list with the commission or the merging parties. It's only trying to say, tribunal, you must hear my views in the hearing. And we say, you will be heard because the commission can call you, tribunal can call you. You just won't get to do the commission's job. That's all that this appeal is about. So the cloaking them as an intervener is the limit of what this fight would be about. And that would be the only thing that this appeal renders res judicata, that you're not an intervener. But if Lewis came and made submissions and then said, oh, you ignored me and I was really important, it could go to the High Court and try to review the tribunal, or it could go to the Competition Appeal Court and review the tribunal.
Okay.
So it's not without recourse if it thinks it was ignored. But Justice Majid, that possibility.
No, I'm Matopo. Majid is done with you.
Sorry. Sorry. The problem with that scenario is that this is the commercial context that these cases take place in that I must address in response to your question, which is this. Stalingrad happens in mergers as well. Competitors have an incentive, they have an interest in their competitors' mergers taking as long as possible and preferably not taking place at all, because they go past the long stop date, they get abandoned, the deal falls over commercially because it took 4 years, 2 years, 1 year. Competitors abuse intervention. I'm not saying that is necessary.
No, but sorry, Ms. Lero, this is not your case, the Stalingrad.
No, but the CAC acknowledged that Stalingrad can happen because competitor interveners have this interest.
But
and so the CAC decision.
But today that is not your case.
Yes, but it's this risk of permitting competitors to protract and delay merger control, which must be expeditious because commercially you want deals to get approved or prohibited quickly. That context does matter here, because when Lewis comes and says, oh, I'm really worried about low-income consumers, with respect, it's a claim that must be treated with great circumspection for the simple economic reason, Justice Matopo.
Let me ask you finally ask you this question.
Yes.
When Lewis presents its evidence before the January hearing, would it be able to show that it has the ability to assist? Would it be one of its averments that it has some special and unique characteristics to the case? Will it be able to do that? or it loses it?
Justice Matopo, with respect, let me just clarify. January is not a hearing into the merits of the merger. January is a deadline for the commission to file its supplement.
Let's put it this way. In the forthcoming hearing,
in the eventual merger,
whatever time,
in the eventual
once
merger
everything
hearing,
has been collated.
yes. So in the eventual merger hearing, where Lewis is there either because the commission calls it or the tribunal invites it, it doesn't matter that it says I can assist you. It's assumed in the invitation. So ability to assist is only relevant because it's the test for intervention. And here we say it didn't demonstrate that ability because of the deficiencies of its affidavits that I went through. So at the eventual merger hearing, it doesn't matter how much assistance Lewis gives. It will then come with its view of the market. It will then have to put its store managers or its marketing managers or its supplier managers into the witness box, and they will have to testify with facts about why this merger is bad for competition. So they don't have to do ability to assist if they're there through the commission or through the tribunal.
Thank you for the clarification.
Thank you. Thank you, Justice.
Thank you, DCJ.
Thank you, Justice Matopo. Any other questions, colleagues?
Yes, can I ask a question?
Please go ahead, Justice Rogers.
Ms. LaRue, I want to take up the question that I asked to your opponent in this matter. If the CAC said that the test was whether the intervener was possessed of information which could not be otherwise obtained and placed before the tribunal by the commission, would that be a wrong or a right statement?
If that was what the court said, it would be a wrong statement because we submit that is not what the court said.
So we can accept that it is not a reason, or it is not a judicially correct approach to refuse intervention because of the fact that the evidence which the intervener has disclosed in its founding affidavit for intervention could be investigated by the commission and supplied by the intervener to the commission, and in that way placed before the tribunal. That's not a legitimate mode of reasoning.
Yes, because that would draw a line through Tribunal Rule 46.
Well, it would draw a line through all intervention except in those cases which nobody has yet indicated, where through inquisitorial and investigative powers, the commission and the tribunal between them can't get the information.
Yes.
So what I'm looking at what the CAC said in the last sentence of paragraph 48 of the judgment, and I'm not looking in case lines. I have it on the Staffley version. If you want to just quickly locate it.
Paragraph 48.
Yes.
That's 012-45. Yes.
Mr. Quinn will direct our attention to it. In short, the affidavits fail to show whether the respondent is in possession of evidence which would not otherwise be available to the tribunal after requiring further assistance from the commission, and which would therefore assist the tribunal in determining the likely effects of the merger. I had understood it in the way that I framed it to you, and which you say would not be correct. How should we understand that statement?
Justice Rogers, let me say two things in response. The first is that I read that sentence to be, because the overall paragraph 48 is assessing the sufficiency of the evidence set out for intervention. It's the screenshots argument. It's the Google Maps argument. So I read that sentence as concluding by saying the affidavits don't put up insider knowledge. Because what that whole paragraph is dealing with is that the high watermark of the respondent's case is that the commission's report is inadequate and that it criticizes that and therefore material differences. So when I read that final concluding sentence of paragraph 48, I understand the context there to be, you promised me unique inside retailer knowledge, but you didn't give me that in your affidavits. So when the court says, failed to show whether the respondent is in possession of evidence which would not otherwise be available to the tribunal, I understand that to be the statement that the court makes somewhere else in its judgment, but hopefully my learned juniors are finding it, where it says anyone who could access Google could do what was done in the affidavits. Justice Rogers, I hope you recall that sentence. So I understand this sentence to be saying the same thing. Anyone could go on Google. That is information that would be available to the tribunal or the commission because they can go on Google too. Where's your special
anybody can go onto
knowledge?
Google. Anybody can go onto Google to find case law, but you need some knowledge to know what you should be looking for. And it seems to me that even Google searching may be relevant because Lewis knew what it was looking for and used its experience as what it regarded as primarily a three-player market to focus on what it thought was going to be relevant. But either way, I'm content if you say that. I mean, we'll have to decide what we thought the CAC was saying, but you do not say that an insider or a competitor needs to show that information which it could not place before the tribunal through the commission. You say that's not the correct test, and you don't believe that's what the CAC was saying.
Yes, Justice Rogers. And if I could just bolster that submission by saying, if you look at what the next paragraph 49 says, and I think the two paragraphs reveal the court's reasoning on this point. What paragraph 49 says is it looked at these competing versions, and that's the problem, because that is patently the incorrect test for intervention. So it finds the tribunal is clearly wrong there and therefore intervenes. And then the concluding sentence of 49 is crucial. On the basis of the case made out by the respondent in its affidavit in the intervention, the test concerned the unique contribution it would make in producing relevant evidence before the inquiry that it regrettably failed to do. So I understand the conclusion in 48 and the concluding sentences in 49 to be read together to say you didn't give me your insider knowledge. And that's what I was looking for. I don't understand it to mean the tribunal can't use Google too.
So unique contribution is what Lewis knows from its own experience.
Yes.
That's unique.
Yes.
You say that's part of what the commission is now investigating. One would be surprised if Lewis weren't able to place that unique contribution before the Competition Appeal Court. You say it's not the whole picture, but I don't understand you to say it needs to be the whole picture. Lewis is, if it is not the only constraint on the merger parties, must surely be a significant constraint upon them. And is it not inherently probable that it would have unique inside information?
But Justice Lewis, Justice Rogers, this is where the Competition Appeal Court finds Lewis goes wrong, because it says you came along and said, I've been a retailer for decades, I'm their closest competitor, I'm going to tell you the inside story on how this three-player market works. The court then looked at its affidavits and said, your affidavits do two things. They give me Google publicly available price information or Google Maps, and you take pot shots and find shortcomings in the commission report. Nowhere do I find that insider insight that you tell me you have. And that's where we talk about we don't have the internal documents of Lewis that say it's definitely a three-player market and this is why. We get a promise that it will lead evidence and that its external attorneys and experts will scrutinize the confidential information and find problems. But they don't put up why their insider view of a three-player market is actually the correct view. And that is how I read the Competition Appeal Court to be reading those affidavits. It says that wasn't, you told me you were going to come and tell me a special story about a three-player market, you didn't give it to me.
So on the merits, we are going to need to read the founding affidavit in the intervention application and say, is it devoid of anything significant in insider information?
Yes.
And if it is, the CAC was right. And if it is devoid of it, the CAC was right. And if we consider that there is inside information, which could include lines of inquiry which come from inside information, Because bear in mind, it may be that ultimately an expert economist gives evidence or is adduced by Lewis if it has full intervention rights. But the economist's report might itself be shaped by the information or the insights it has obtained through consultation with Lewis. But either way, it seems to me it's going to stand or fall on the merits and whether we consider that it is devoid of inside unique information. Unique, I mean not that only Lewis has similar experiences, but that I think I understand you to define unique simply as being coming from Lewis's own experiences.
Yes.
Other competitors might have similar experiences, but it's enough that it comes from Lewis's experiences. And if we find the affidavit devoid of that sort of contribution, you will say the CAC was right to find that the tribunal misdirected itself.
Justice Rogers, with respect, I'm in absolute agreement with all of that, with one extra point. When you scrutinize the founding affidavit with respect, you will also see promises to produce things. And the CAC correctly says, no, the time to produce is in your intervention founding papers. Don't promise to lead evidence in due course about XYZ. Tell me what that evidence is now so that I establish your ability to assist with your insider knowledge. Don't promise to...
It surely doesn't have to be all the evidence. As, for example, in an application to adduce new evidence, you might indicate what the new evidence will cover, but not actually adduce it until you have permission. So if intervention stands in this case, that evidence will be forthcoming. There must be a sufficient indication in the intervention of what the nature of that evidence will be and of Lewis's ability to give it from its own commercial experience as a competitor.
And Justice Rogers, because what the affidavit gives you, in addition to the Google screenshot publicly available information, is it says, we will look at the information put up by everybody else and tell you why it's wrong. But that's the privatization point. Only the attorneys and economists will look. The missing part here is Lewis's voice, not the attorneys and economists that Lewis has paid to scrutinize everybody else's information. Where is Lewis's information and evidence? Where is its voice? Not just the voice of its attorneys and economists privatizing the commission's powers. That's the other part of the commission, of the CAC's reasoning that we, with respect, endorse and commend to the court. It says, I don't care how your lawyers would have done the commission's job or their economists would have done the commission's job. What's your story on why it's a three-player market? Not just a theory.
Thank you. Thank you.
Thank you, Justice Rogers. Any other questions, colleagues?
Can I just deal with Ms. LaRue, with the issue of the order? You seem to say that the order, if we were not with you, what would the assessments to the order be?
Justice Savage, so the primary and main submission that I must just make again is that on these founding papers in the intervention application, the only legitimate order is, application for intervention dismissed.
Yes, that's certainly noted.
But in the hypothetical world that I'm resistant to enter, it would be at most on the 4 issues identified: market shares, competitor constraints, and online. It would only be that Lewis can lead its own factual information on that. It can make production and it can have a factual witness. And it can make some submissions on that. But that is it. It would not be an intervener who could call for discovery from everybody, who could call experts, who could cross-examine everybody. At most, it can come and make its factual information available to the tribunal. Nothing on remedies, nothing on conditions, and no access to everything else. It can only come and tell its story.
And what would justify that restriction?
That restriction is the northern approach. So it came and said, I have a view of this market, At most, it should be allowed to have the procedural rights to call its own witnesses, which is, of course, an additional procedural right, because in the statute, 53C5, you're only entitled to question witnesses, not call your own. So it's already an additional right to provide your own witness. And you can inspect documents, not necessarily produce your own if you've got intervention rights. So the ability to call its own witness would be the one thing it could do, and it could give some documentary evidence. Anything else we say is for the commission to do, because Lewis itself won't be working up cross-examination or calling for discovery or looking at any discovered documents that come from any other market participants. That's the privatization problem. So at most, it must tell its version on the 4 topics. I say your market shares are huge. I say we're the closest competitors. I say customers only shop at the 3 of us, and online isn't a constraint. That's what it can do.
Good, thank you.
Thank you very much, Justice Savage. I don't see any other questions.
I just have one quick question.
Oh,
Thank you,
Justice
DCJ.
Holopin, yes, please go ahead.
Thank you, Ms. Leroux. You indicated quite earlier on, in response to one of my colleagues' questions, I can't recall who, that one can't rule out the possibility that the tribunal would have, even if Lewis hadn't sought to apply for leave to intervene, made an order directing the commission to conduct further investigations. Is that correct? You say one can't rule that out.
Yes, Justice Colburn. We saw that in the Altec case.
But can I just get the date on when the tribunal made such an order?
Justice Colburn, I'll have to get you the dates for that in that decision. But what you'll see I can give you is in the record.
Doesn't matter. We could get to that. I just want to raise the question whether that proposition that you made, that but for Lewis, there may still have been a tribunal requesting the commission to conduct further investigation, may be somewhat not borne out by the timeline, because as I understand the timeline, the commission had submitted the matter to the tribunal on the 14th of April, recommending conditional approval, correct? On the 30th of April, the tribunal writes to the parties who had participated in the commission investigation, asking them if they have any additional concerns. And the matter had already by then been set down for the 2nd of May in chambers. That would suggest that the commission, well, the tribunal hadn't at that stage raised any concerns. It was proceeding with set down, and then Lewis came in. I just raised that as suggesting that Lewis had in fact raised its concerns to the commission during its investigation. It says that those concerns were not reflected adequately in the commission report. And is it not reasonable to assume that at the point at which the tribunal was 2 days away from an in-chambers hearing, it had done nothing and therefore would have been quite satisfied with what was placed before it?
Justice Colburn, with respect, I'm indebted to you for the opportunity to clarify something. When the tribunal, in its reasons, and this is set out paragraphs 18 to 24 of its reasons, that timeline, when it says that while waiting for responses, it set it down for an in-chambers hearing on the 2nd of May, that is not necessarily the merits hearing. Because what happens in practice is the tribunal panel that has been allocated the merger will sit in chambers to consider the recommendations of the commission on a large merger. On the 2nd of May is when the tribunal may have said, oh, I've got problems with your market share analysis or the investigation of the online market or, you know, the commission's analysis on local markets. And at that point on the 2nd of May, directed that it wants more information. That's how it works in practice. So the 2nd of May is not the decision day for the tribunal. It's when the panel of 3 sit and look at the recommendation and the record and decide what they want to do. One of the things they could do is say, Commission, I need help, or I need to hear from so-and-so, or I'm going to set it down for a hearing in public to address this and this and this. That's what happens. So the 2nd of May is not decision time.
Sure. My last question, Ms. Leroux, is that the tribunal did allude to this difference of views, which it said needed to be resolved. And the CAC took issue with that because that's not the basis on which one would seek and obtain an intervention order in your favor. However, the tribunal also substantively and apart from that set out what it thought was Lewis's contributions. And that would appear from sort of paragraph 55 of the tribunal's reasons. CAC took a different view on that, and I think you've dealt with that quite extensively. Ultimately, if this is a question of the tribunal taking one view and CAC taking another, and both justifying why they take those different views, would that satisfy the test of interfering with the exercise of a true discretion?
Justice Cotman, we would say it does, because whatever paragraph 55 of the reasons say, it's the tribunal's order that was appealed because it has all the material misdirections and clearly wrong errors in it because of how it was framed. So the CAC needed to set aside what is clearly an unlawful and irregular order, and that is what it did. So whatever paragraph 55 of the tribunal reasons say about that it thought these images were quite useful is not why the Competition Appeal Court had to intervene and set aside that order. It had to do it because the terms of the order were completely indefensible, and Lewis hasn't even tried to defend them. That is the problem, and that was why the CAC correctly.
Yeah, but in response to earlier questions, do you accept the distinction that if we would find that CAC was wrong to interfere with the tribunal's conclusion that Lewis was entitled to intervene, but that the tribunal may have erred and misdirected itself in granting the wide order that it did, then surely we would be entitled to separate those out and deal with, as Justice Majid had put to you, trimming the order. There would be nothing impermissible in that, would it? I'm just asking you, I'm not asking you to defend the first part. You've done so quite valiantly. I'm just asking you, as a matter of principle, it would be within the remit of this court to take such an approach. You may disagree with that. We should do so, but yeah.
Yeah, would vigorously disagree. Yes.
Yeah. Okay. You don't need to do so now again, but I'm just getting that. Yeah. Okay. Thank you, Mr. Leroux.
Thank you very much, Justice Colopan. I don't see any other questions. Thank you very much, Ms. Leroux.
DCJ, I must just for the record say that obviously we have all of our arguments that are set out in our answering affidavit and our heads about why leave to appeal should not be granted. And I don't know if there are any questions on the leave to appeal debate. I've left it till last, but obviously we say that is the first off-ramp that the court respectfully ought to take here. This is not a constitutional issue. There's no right engaged here, and this is not an arguable point of law of general public importance, and it's not in the interest of justice for the court to hear the appeal. So obviously we still persist with the leave to appeal arguments.
Thank you very much. Thank you. Okay. Mr. Manager or Mr. Kotsodis, who's going to do the reply?
I'll start first, Justice DCJ, and thank you. I'll deal only with the arguable point of law as a question of jurisdiction. The first point to make is our learned friend's argument that there is no new test. And Justice Rogers referred to paragraphs 48 to 49. We would like to refer also to paragraph 52, the court to paragraph 52, because that paragraph evidences precisely the test that the CAC applied in conclusion. And it said in paragraph 52, in summary, the manner in which the tribunal approached the application for intervention reveals that it did not take sufficient account of the fundamental test laid down by this court, namely to what extent was the respondent as an intervener likely to assist the tribunal in circumstances where the information and evidence it was intending to provide could not have been obtained elsewhere. That's either a new test or it is a wrong test. And on either account, it is an error of law in terms of the majority decision of this court in Villa Crop Protection at paragraph 64 to 65 that it adopted a wrong legal standard to determine whether the tribunal decision had to be interfered with, and that engages the jurisdiction of this court on the point of law. And that point of law is arguable because the KEC does not apply itself to whether that the previous test was wrongly decided, and it develops a new test. The second point our learned friends made is the KEC was simply enforcing Rule 46 2B, which is not to admit Lewis, not to admit Lewis because its interest was already covered. But at the time of intervention, Lewis's interest was clearly not covered, and that is why the reasoning of the tribunal and the KEC's own acknowledgement at paragraph 61 of its judgment that Lewis must participate in some form. The fourth point about the arguable point of law is the interference with the tribunal's exercise of discretion without showing deference to the tribunal, and in a manner which we submit is improper because the KEC does not say that the findings of fact on which the tribunal exercises discretion constituted misdirections of law or were clearly wrong, or that it applied the wrong principle of law. And Mediclinic at paragraph 44, quoting Emeris, makes it clear that the KEC does not enjoy an unbridled power to interfere with the tribunal specialist decision. So that's another point of law of importance that is arguable. In relation to paragraph 61, our learned friends argued that what the KEC did at paragraph 61 is simply a question of packaging the manner in which Lewis should participate. With respect, the question of packaging under section 53, it's an issue that falls squarely within the tribunal's discretion. It is not a matter over which the KEC can say, I disagree with you, tribunal, that given what Lewis has demonstrated, it can only participate as a witness effectively on invitation under paragraph 61. That again is an interference with the tribunal's discretion, which raises a question of law. And our learned, to try to rescue the paragraph 61, our learned friend says, but if Lewis is invited to present evidence, in other words, it participates as a witness, it'll have all the rights of an admitted party, for instance, to review the decision or appeal the decision if it was unhappy with the outcome. That's not correct because the law is quite clear that a witness has no similar right to a party. You can't challenge a decision because you're dissatisfied with findings against the evidence you presented. And this court's judgment in Lebea versus Menye says precisely that in relation to appeal rights of a witness. So we submit that contrary to our learned friends' concluding submissions, there is an arguable point of law which justifies this court's general jurisdiction, and we submit justifies the grant of leave to appeal. My learned friend, Mr. Koutsoudis, will deal with reply on the merits unless there's a question for me. Thank you, DCJ.
Well, let's hear Mr. Koutsoudis. Then, if there are questions, they'll be for both of you. Thank you.
Thank you, DCJ.
Mr. Koutsoudis, on the merits.
Yes, DCJ, if I can, I'm going to deal with four main issues, but I'll deal with them very briefly. So the first one is there was a number of questions to Ms. LaRue about what would have happened but for Lewis's intervention, because I made the submission that Lewis had clearly demonstrated its ability to assist because there was a before and after picture. Before, we were headed for an in-chambers inquiry, and after, we were left in a situation where there is now a realization that there are significant further work to be done to properly understand this market precisely along the lines that Lewis had submitted. Now, Mr. Roux said to us, we can't really understand what would have happened. One mustn't read too much into the fact that the tribunal was going to have an in-chambers hearing. And she's made a lot of that. But can I just read from her client's answering affidavit in the intervention? And I think this is quite important. Paragraph 17 of that answering affidavit, which appears at 011.1, page 76. And this is what Ms. LaRue's client says. that the proposed transaction does not give rise to Lewis's alleged concerns is further reinforced by the fact that after considering the Commission's report and record, the Tribunal opted to decide the matter in chambers. So her submission on affidavit in paragraph 17, page 76, is precisely the opposite to the submission being made now. It was, you must read something into this. The Tribunal clearly doesn't have a concern here. It's looked at the record, it's looked at the report by the Commission, and there's nothing to see here. And the simple reality is, in fact, as we submit, there was much to be read from that. That in fact, the fact that it was going to be in chambers did indicate that, but for Lewis raising the concerns, it would have ended in an in-chambers hearing where there wouldn't have been the type of detailed scrutiny which we have suggested needs to occur, and which we have suggested we are able to provide insights and information in relation to. Then, my learned friend, Mr. Manetshi, has already dealt with the question of the test, and Justice Rogers and Ms. LaRue engaged significantly on this test. But I would like to just zero in on a concession that Ms. LaRue made, as I understand it. She accepts that if indeed what the Competition Appeal Court did was to say that what you have to show is that you have information and evidence that would not otherwise be available even from the Commission undertaking further work. She says she accepts that if that is what the Competition Appeal Court was doing, that would be a wrong test. And all I would emphasize, as emphasized by my learned friend Mr. Manetshi, is that if one reads both paragraph 48 and 52, it's very clear that that is precisely what the Competition Appeal Court was doing. And it's the only way to understand why it kept Lewis out, because it didn't interrogate all the reasons for what the Tribunal had to say about how Lewis was able to assist, the nature of the knowledge it had, and the details it provided. And that brings me to my second point, which is the ability to assist. Ms. LaRue says she accepts that the test is only, can Lewis assist? And she even accepts that in principle, Lewis would have unique insights. She accepts that in principle. Her answer is that, well, even though she accepts in principle, Lewis would be the type of competitor that would have unique insights, she says we didn't show them. We didn't do enough. But if one has a look at, I want to make 2 points on that. The first is the starting point must be the trier of fact. And I took this court to various paragraphs in my opening. Paragraph 55 of the reasons, 56, 62, 65 to 69, where the Tribunal summarizes the ways that Lewis was already able to demonstrate the nature of its knowledge and its assistance. So the first point would be that the Competition Appeal Court would have had to have said these findings by the Tribunal as to the nature of assistance that Lewis has already demonstrated are wrong. It doesn't do that, let alone saying that there's a misdirection. And it's one line statement in paragraph 48 doesn't do that. But it goes beyond that, because as Justice Majid and Justice Rogers have interrogated, you would have to look at the actual underlying affidavits. And if I could just give some general references to this court. The founding affidavits, paragraph 60 to 67, paragraph 82 to 83, paragraph 26 to 35, and replying affidavit 23 to 30. In all of those, what you see is not just generalized, there's this caricature by Ms. LaRue that there is just Google desktop exercises. But what you see there is specific competitor by competitor analysis. Each of the competitors that are supposedly in this market and that supposedly constrain the merging parties are analyzed. And Lewis's deponent says, you've included this competitor, but look at the type of product it sells. Look at where it's positioned. Look at what it does. It's not a comparable competitor. So it's not as if Lewis just doesn't give any specific details. It specifically provides insider knowledge about who these competitors are.
Mr. Koutsoudis,
yes.
You've run out of time.
Can I make two last submissions, if that's in order, or one at least?
2 minutes.
2 minutes.
2 minutes.
Thank you, Dev. I'm indebted. I would make 2 last submissions, because we say that once you look at the affidavits, assistance is clear. Then the question is, once you're in as a participant, because if it's accepted that you're in as a participant, then you should be given rights to make your participation meaningful. There have been many debates by Ms. LaRue about the nature of the rights given. And we would say that we simply would draw the court's attention to the following. In the notice of motion, Lewis seeks the rights it asks for and was granted, and it asks for broad intervention rights, and it justifies these in its founding affidavit. In response, in the answering affidavit, if you look at paragraph 71 and 74, there are just generalized disputes and denial of those rights. And in fact, the deponent of the answer affidavit says these issues should be debated before the tribunal. They were debated before the tribunal. The tribunal then sets out in detail from paragraph 69 why the rights are necessary. And the important thing is this: unlike in Northern, where the tribunal refused the rights, so therefore it was the duty of the appellant to say why the rights should nevertheless be granted. In this case, the onus is reversed. Here, the tribunal justifies the rights. It says these rights are needed for these reasons. And therefore, it would be the other way around. You'd have to say, let's look at these reasons that you've given in paragraph 69 and onwards. Are they wrong? Are they material misdirections? And that is the glaring failure in this matter. There's been no engagement either by the CAC or by Mr. LaRue as to the reasons given by the tribunal as to why discovery and a knowledgeable insider asking for documents, cross-examination, using expert witnesses, why that would be improper. And my last concluding point would be, there's some suggestion that this order is somehow unusual. There are many cases over the years, including cases that involve Mr. LaRue's own client, Pepkor, in a merger between Prepaid and Cell C, where very similar rights are granted. Rights to call witnesses, rights to call expert witnesses, to cross-examine with witnesses, and to ask for documents that may be relevant in order to allow for discovery. All of that is completely normal. And even if one looks at all the CAC judgments, one sees similar rights granted. Chief Justice, Deputy Chief Justice, Justices, I won't detain the court more. Those are my submissions.
Thank you very much, Mr. Katsoudis. Colleagues, are there any questions for the reply? Okay, there are no questions. Thank you, Counsel. This court reserves judgment, and this court is adjourned. Thank you.
Thank you. As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.